All right, everybody, it's 7:30. Would you like to start on time? It's March 6th, 2025. This is the Highland Park Planning Board. This meeting is called to order in accordance with the Open Public Meetings Act. Notice of this meeting was provided to the Home News Tribune, the Star Ledger, and the Highland Park Planet on February 3rd, 2025, and was posted on the borough website at www.hpborough.com and on the bulletin board at Borough Hall, 221 South Fifth Avenue, Highland Park, New Jersey, and has remained continuously posted as required by law. Fire exits are to the left and right of the chambers. And as a reminder, please do speak into your microphones when it's your turn. I know it's very easy to forget that, but do try to remember to speak into your microphones. All right, actually, we're going to do the Pledge of Allegiance first, which is a new addition to our agenda and an odd oversight of ours. So. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone, and we'll take roll call, please.
Ms. Hand.
Here.
Mr. Brescia.
Here.
Mr. Chin.
Here.
Ms. Hazy.
Here.
Mr. Hale.
Here.
Mr. Linares. Mr. Malay.
Here.
Mr. Perlman.
Here.
Mr. Stern Cardinal.
Here.
Mr. Williams.
Here.
Mr. Thomas.
Here.
Mr. Cosenza.
Here.
Mr. Koch.
Here.
All right, first up is a review of our draft November 7th, 2024 minutes. Do any members of the board have any comments on the proposed minutes? Changes, comments, modifications, anything? All right, if it's acceptable to the board, I'll solicit a motion to approve the November 7th, 2024 minutes.
Motion to approve.
Motion? Any second?
Second.
Seconded by Alan Williams. Roll call on this one?
You don't have to, but if you'd like, you can.
We'll take a roll call, please.
Okay. Mr. Brescia.
Yes.
Mr. Chin.
Abstain.
Ms. Hazy.
Abstain.
Mr. Hale.
Yes.
Mr. Malay.
Abstain.
Mr. Perlman.
Yes.
Mr. Stern Cardinal.
Yes.
Mr. Williams.
Yes.
Ms. Hand.
Yes, thank you. Next up, we have a resolution P2025-01 for the SYC Realty LLC, minor site plan and C variance waivers memorializing the actions the board took at our last meeting. Are there any comments from the board on the language for the resolution? This one.
On page 2. There. In the first paragraph on page 2, the restaurant is at 231 River Avenue was. I mean, it's still there.
Thank you for that tense change. Thank you.
Okay, and on page 7. Under requirements, number 6.
Yes.
And it says, in the comments of its planner. I don't believe that they had a planner. It was the lawyer and the engineer.
I believe you are correct. So we'll take out the words and its planner.
The revised ordinance or revised resolution indicates that the applicant and the applicant's planner, engineer. And yeah, get rid of the word planner. You're right. You see that there. Got it.
Anyone else? Seeing no other amendments, I'll solicit a motion to approve the resolution subject to the 2 modifications we just discussed.
Motion to adopt.
Motion,
Second.
seconded by Mr. Williams. Take a roll call, please.
Mr. Brescia.
Yes.
Mr. Chin.
Yes.
Ms. Hazy.
Abstain.
Mr. Hale.
Abstain.
Mr. Malay.
Yes.
Mr. Perlman.
Abstain.
Mr. Stern Cardinal.
Yes.
Mr. Williams.
Yes.
Ms. Hand.
Yes. All right, very good. So that takes us to our next item on the agenda, a public hearing for a preliminary investigation of a condemnation area in need of redevelopment regarding Classic Cleaners, block 1704, lots 43, 46, and 49, Here's how this matter is going to be handled this evening. We're going to have our planner make his presentation to the board. The board will have the opportunity to make preliminary questions or observations. After that, we'll open this up to any attorneys that are in attendance this evening who wish to be heard, and from there, members of the public who are physically present, followed by members of the public who are attending virtually. So please be mindful that we will do our best to give everybody an opportunity to be heard. We are going to ask that you limit comments to 3 minutes, so everyone has that opportunity, because I see lots of participants here this evening. With that said, we will work very hard to make sure everyone gets their turn, so please be patient with us. So with that, I will turn this over to our board planner, Mr. Cosenza, for his presentation on his preliminary investigation. Thank you.
Mr. Cosenza, just for the purpose of the record, you swear affirm the testimony that you're about to give will be the truth, so help God.
Yes, I do.
And then just for the record, also state your name, spell your last name, and the location of your office, please.
Chris Cosenza, COSENCA, Office of LRK Incorporated, in Philadelphia, 1218 Chestnut Street.
And obviously you are the planner for the borough, is that correct?
Yes.
Why don't we proceed?
1 second, please. I'm Chair, members of the board, members of the public, thank you for coming out to an investigation of the classic cleanup property. I just want to start off with saying, just so generally speaking, over the past 20 years, the borough has undertaken several planning activities to really try to make the community a vital place to live, work, and play, and really has recognized over the years that there's a need for sustained attention for our downtown area. Also acknowledging that past revitalization efforts had not really had a great impact downtown until recently. And that's because for a variety of reasons I'll get into about the overview in a few moments. In 2003, the borough actually embarked on a process to really envision what it could be in the downtown area, and actually includes the subject property, the classic cleanup property I'll refer to for the presentation. This is block 1704, lots 43, 46, and 49. This constitutes the study area. In terms of the agenda, I'm going to go over a few items. As you're probably familiar with my types of presentation, we try to give detailed breakdown and structure to it, so it keeps you understand bites and the logical line of going through this process. In terms of I'll give you an overview, basically the history of where we were and how we got to where we are today. Just a brief overview on redevelopment statute and why we advantages to the borough of Lofton Park, and some context about the study area as well as the evaluation itself. That's the meat and potatoes of the presentation. And then we'll conclude with the summary and recommendations for the board.
Sorry, Chris, can you speak a little closer to your mic? We're competing with the noise coming from
It's like a party. So generally speaking, the study area is located in the central western portion of the downtown area, with frontage on Barrington Avenue, State Route 27. It's consisting of 3 lots, about ½ acre, total size collectively. Generally speaking, I would say it's an odd-shaped parcel with 3 odd-shaped lots. And I will say that beginning in 2003, the borough took a look at the downtown areas and really wanted to understand what it could do for really improving the environment. So it started with going through a master plan effort in 2003 and really identifying there's issues downtown, including the need for redevelopment. Starting in 2004 and concluding in 2005, the borough adopted an area in need of redevelopment designation for all the properties highlighted, including the study area. And so recently in September 2005, they adopted the downtown redevelopment plan, which provided basically new zoning and vision and traffic regulations for all the properties highlighted in orange on the screen. As I indicated At the outset of the presentation, not much has happened through that redevelopment plan other than a small site by the International Food Market. And over the years, the borough understood the need to make various amendments to try to spearhead and promote some development downtown. I believe there were 7 amendments, and it really came to a conclusion back in 2016, about almost 10 years ago. The borough took a new step and determined that the best way forward was to really take advantage of the redevelopment statute by designating the entire community as an area of rehabilitation, so it applies to the entire community. And in 2019, the borough adopted its most recent master plan with a focus on downtown development. In its land use plan element, we had a lot of focus on what could we do to promote livability downtown. And one of the comments made by the public was, I love the feel of our downtown, but the area between First and Second Avenue is major tension. And that these are the properties that were studying tonight. In 2020, the borough, in its effort to kind of promote the downtown redevelopment, they began to start to utilize the redevelopment statute again by studying the properties adjacent to the classic cleaner site. This is the Gun and Boat property and the vacant properties to the rear on Denison. So the borough did an area need redevelopment with condemnation, and that designation was adopted. And after that, the borough adopted a redevelopment plan for the property that we commonly call as tracks A through D. The study here is actually in track A. Track B is across the street between South First and South Second. Track C is basically a farmer's market property, and track D was a primarily a parking area on North Third. In 2000. After the redevelopment plan was adopted, the borough went through RFP process to identify and really try to promote the opportunities for downtown development and invited developers in the community to respond with their concept plans for tracks A to B. Several concept plans were submitted and reviewed, and ultimately the borough selected 2 redevelopers, one for track A, that would be Dev Tent Lift and Raritan LLC group, and they selected Garden Homes for track C, which is the farmer's market property. In between the RFP process back in 2022 and the most recently amended redevelopment plan, the borough authorized an area need redevelopment study for properties on track C, basically to expand the redevelopment designation for track C. And upon designation of those properties as a non-combination area need redevelopment, the borough adopted an amendment to the downtown redevelopment plan. And that amendment still kept in place the zoning standards for track A, which is for the classic cleaner property, but primarily focused on enhanced vision for the track C parcel for our homes. So I would say over the years, the borough has, as it relates to track A, has purchased several properties within track A, almost all the properties except for the southern property, the classic cleaner property. The borough has sought to purchase the property and actually went through an effort to assist with the cleanup efforts back in 2017. And at this point, given that the borough now has ownership of all the properties, including taking title to the Woodbridge property, the Woodbridge is now opening the shop on Woodbridge Avenue, the Borough Council determined that it was necessary for the planning board to conduct a preliminary investigation for a common area need redevelopment for the classic cleaner site. Consistent with the statute since 2013, the borough is required in its resolution to the planning board to indicate whether it would be non-combination or combination. Non-combination meaning that the borough will not use the power of eminent domain. Combination means that they could use eminent domain, but they have to put in a resolution essentially to declare that their intention they may or may not use, but the power is available to that. And it's sort of a point of clarification, as the Madam Chair indicated on the outset, this is a combination area review. It does not mean the borough will use it, it just means that they can. I think from prior experience, the borough has used a combination designation for the adjacent properties to the east, the Gun and Boat properties, but they did not use, they did not proceed with condemnation procedures. They eventually were to purchase the property through arm's length agreement. If I can speak for mayor and council, the preference obviously is not to use condemnation, but it is a strategy to get the people to the table and consider development options. So in terms of the scope of study, really the evaluation. So those are really detailed effort. Inventory makes site detailed site inspection, but gone out there several times. Review all available records. In this case, there were not very many records on the property. There were some zoning permits and a bunch of construction permits, but very little records from the health department, as well as from police and fire. Otherwise, there is a review of zoning ordinance and master plan and analysis of physical conditions based off the site inspections. And also, as a conclusion, indicate by findings and recommendations. So, generally speaking, let's switch my pages here. So generally speaking, the local redevelopment housing law was really largely based on the 1949 blight area statute. It's been designed to guide municipalities and local governments through the process of rehabilitation and redevelopment. Before the borough could entertain, or any municipality could entertain using the powers of redevelopment or rehabilitation, an area must first be designated an area unique, whether through rehabilitation or redevelopment, and then at that point they can adopt the redevelopment plan for other programs for rehabilitation. And the borough has largely been successful with utilizing the redevelopment statute and incorporating through its findings and adopting a redevelopment plan for several sites throughout the community. And one of them is on 31 River Road, which is in Frederick. It's a successful redevelopment of the 1 acre parcel into 40 apartments, including affordable housing. And also the restaurant on the former Italian market on Urban Avenue, which is actually on the same block, just a couple, about 100 feet away from the subject property. That was converted to a 2-story building with 5 units, including work housing and a thriving restaurant. In terms of the procedure, as I indicated, the borough, in order for the borough to utilize all the powers of the redevelopment plan, must be first designated an area of rehabilitation or redevelopment. And in this process, we're going through the condemnation area redevelopment, and that process requires that the borough council direct the planning board to do the study, and either the planning board or the governing body will designate a planner. Usually it's the municipal planner who do that work on behalf of the planning board. And what we're here tonight is the public hearing on the study that was authored by my office and on the record on the borough website. So in terms of the statutory criteria, there's 8 criteria, A through H. And according to the statute, the property needs to meet only one of those standards. And I will say that over the years, there's been various case law to indicate that the study must carefully consider all, really utilize the plain meaning of the statute. For example, there's been a case law about net opinion, meaning that you should not rely on my testimony saying, oh, yeah, it meets the criteria, just trust me, that's my opinion. It must be based on actual factual findings. That's called a net opinion. You basically can't do a windshield study. And with regards to certain criteria, for example, criteria E, there's been some case law about how there's a finding that the property was underutilized by relying on certain parts of the statute, but not really focusing on the first part, which was are the title issues that make it a not a productive use. So there's been some guardrails set up over the years by case law to make sure that the study is based on factual findings. There's also, if you review the actual definition of the redevelopment area, it does include properties, buildings, improvements, which of themselves are not detrimental to public health, safety, and welfare, but the inclusion of which is found unnecessary, with or without change in air conditioning for the effective redevelopment of the area which they are part. And in the redevelopment handbook, the most recent edition, third edition came out, suggests that these properties can be included because they are essential for a destination of effectively to redevelop the area in question. Now, in most cases, you recall, sometimes you have an area of land, we do a investigation for a property that there's no redevelopment plan. So you're sort of jumping the gun about what could it be, but there's a little bit of a disjointed effort. This is some of the problems with the redevelopment law, that you have to trust that, yes, you could use this property for redevelopment for a plan that doesn't exist. In this case, we have a redevelopment plan for a tract A parcel, and the borough has been engaged with various property owners, including the property owner for the class community site, to try to purchase and redevelop the properties. And at this point, the property is the only property that has been purchased and assembled into the overall redevelopment area. So this effectively is the proverbial whole donut of the redevelopment effort. So in terms of the study area context, I indicated that the half acre in size, oddly shaped, has some frontage on Barrington Avenue, but the majority of lots actually in the rear, more than 57% of the property is actually vacant of the landlocked lot on lot 43. The existing land use, I go back to the slide, vacant on the lot in the rear, with the parking lot on the west side and the two-story building on the right side. The two-story building consists of the plastic cleaners, dry cleaning establishment on the first floor and 2 apartments on the second floor. The parking lot includes 10 parking spaces, and obviously the vacant lot is a vacant lot with some overgrowth and debris. So now I'm getting to some of the details of the actual evaluation. Give me one moment. So in terms of the exterior building, what I found when I did my inspection, the building was actually in fair to good condition. Some minor deterioration observed parts of the facade and improvements located in the rear of the building. But I did observe that there were at least 2 of the windows were broken, and since they were fully exposed to passersby walking parking area, that can be constituted as a safety hazard. At the rear of the building, there's a wooden stairway that provides access to the roof. However, the stairway itself exhibits wood rot, and there's no guardrails, neither at the base of the stairway nor on guardrails on the roof. So anyone in the public can walk up and possibly fall. And again, that's a constitutes a safety hazard. And as a minor point of deterioration that's really exhibited because of the lack of maintenance on the downspout, the lack of an elbow which pushes water away from into the parking lot. In this case, water is just draining to the base of the building and causing deterioration. On the inside of the building, particularly the first floor, did not get access to the second floor apartments. But the first floor actually was in a pretty fair condition. What we did observe that there was some water deterioration, staining, and chipping paint, mainly in the back of house area, and there's potential for mold. At the bathroom itself, appears to be substandard by most conditions. The bathroom itself lacks black interior wall and floor finishes, which just really expose the underlying floor and an unfinished block wall. In addition, there's some signs of substantial water staining on the concrete floor, which leads right to the threshold of the door. You can see that there's some rotting, and really the sheathing is really entering into a state of disrepair, exhibiting some wood rot as well. The basement actually was very clean. It was one of the first times I ever come across a business where the basement was actually completely clear of debris. When I went to the stairwell right underneath the sidewalk, we did notice that there was some cracking in the perimeter, so there was some water infiltration and leads at the base of the access well. And unfortunately, we did find elsewhere in the basement that the unused air compressor was leaking oil into the basement floor. Move on to the exterior property. We focus on the parking area, really layout and design. What we found here is that the parking lot really does not comply with most zoning standard development regulations, as well as site plan best practices. Easy to say for an existing condition. If you had a blank slate for sandbox, you would do it this way. But we just want to note that the parking lot does not have good, well-designed ingress and egress and accommodations for accessible parking, and it's just generally inefficient in design and layout. So on the west side of the property, there are 9 parking spaces, but only about half of them are usable. What we found was that the parking spaces located at the rear of the lot are essentially inaccessible because there are no paved areas for a car to maneuver out and back and towards the street. And furthermore, that portion of the lot that's unimproved is borough-owned property. So vehicles would have to trespass onto adjacent properties in order to leave. If there was a fence put up by the borough owns the property, there's several people would not be able to use those parking spaces. And that's not limited to the extreme, the parking spaces located to the northerly limits of the parking lot. It also includes the 2 additional spaces to the south. So a total of 4 parking spaces, because even on those areas that are paved where a vehicle could be maneuvered out to the parking spaces or the street, that paved area is actually on borough property. Again, if the fence goes up, those spaces can be used. So only about half the spaces are usable. Yes, so just want to show the diagram. So this diagram really illustrates that at the extreme northern part of the parking lot, there's really no space for vehicles to get out past the parking lot, which makes for an inefficient design if it were to be appropriately paved and reconstructed. With regards to the front of the property, there were some issues there where the parking spaces are located directly against the sidewalk. These 2 also suffered from faulty arrangement design, and partly because the egress driveway and associated drive aisle is not in alignment with the actual drive aisle parking lot. As you can see here in this photo, if you were to drive your vehicle straight towards the street, as you should be doing, you will be encroaching onto several parking spaces. And if there's a vehicle or more than one vehicle parked in those parking spaces, that there would essentially be no space for you to exit the property unless you're at a sharp angle, which gives you less opportunity to observe pedestrian traffic to come onto the sidewalk. Looking at this in the reverse direction, you can see that the parking spaces are in direct alignment with the driveway, not in direct alignment with the actual parking lot driveway, drive aisle rather. Additionally, there appears to be a 10th parking space that was, according to our research on parcel line data as well as aerial photography, this appears that it's added without getting site plan approval. This parking space is difficult to maneuver to because where the viewer of this photograph we can see is standing in the sidewalk. So the vehicles parked there. The only way to be able to maneuver out of that parking space is if you back up into the sidewalk, which creates a safety hazard for pedestrians. And here's another view of this direction. You can imagine a vehicle parked there has very limited visibility to be able to see pedestrians walking on the sidewalk. And there's really a lack of pedestrian amenities throughout the parking lot, which will help guide users from the parking spaces to the building. It appears that the only walkway that is provided is being used for exposed trash and recycling. And finally, because the parking lot was recently repaved, it's required by the ADA guidelines to provide an accessible parking space. However, we observed there's no parking spaces to go for the mobility disabled, and there's no access aisle. So of the 10 parking spaces that are provided, it's estimated, in my professional opinion, from the site plan design, that only have 2 or 3 spaces are actually viable. In terms of the perimeter of the lot, there are, generally speaking, curbs and wheel stops provide multiple purposes, and if you prevent motorists from pulling through parking spaces, and they sort of organize parking in a manner that makes it efficient in use. Without curbs and wheel stops, vehicles tend to park away from the end of the property, which results in a condition where vehicles will encroach into drive aisles. And that condition will result in driver confusion and poor visibility, and may contribute to a circulation pattern that is unsafe for both visitors, motorists, bicyclists, and pedestrians. Additionally, landscape buffers are often used to help. When paired with curbs, they form landscape lines, and given the lack of same along the street, that means that the parking area is directly adjacent to the public parking lot. Adjacent to the public sidewalk. What that means is that as cars are moving through the parking lot, they may be facing a condition where they may conflict with pedestrians. Typically, a landscape island with an upright curb, which will help manage the traffic and provide protection to pedestrians in the walkway. So this is counter to our principles of our master plan for these streets, as well as Vision Zero. In terms of the driveway itself, typically these are two one-way driveways. And typically when you design a parking lot, one-way driveways are on average at 9 or 12 to 15 feet. And two-way driveways in the middle of the parking lot typically are 24 feet wide, with accommodating 90-degree or perpendicular parking. In this case, you have a situation where you have two driveways about 20 feet each in width, combined at 40 feet, and given the lack of separation between the two driveways, it gives the appearance of a 50-foot wide driveway in the middle of the downtown. And again, these are conditions that result in driver confusion. It encourages conflicts between pedestrians and motorists and represents an unsafe condition detrimental to the public. There's some other conditions, just only in couple spots on the public sidewalk where there's an uplifting, faulty patching. This will obviously result in a tripping hazard, which is dangerous to the public and maybe inaccessible, may force people to go into the parking lot to maneuver around these conditions. And in terms of the waste and waste and recycling areas, again, these areas are typically enclosed in a three-wall structure or a fenced area away from view. In this case, it's directly on the sidewalk, fully exposed to view, and blocks the accessibility for those walking or using a wheelchair to get to the store. In terms of the vacant lot, just based on our observations of these photographs, you see the property does not appear to be actively maintained. I do want to note that in the 2005 area needs study for the downtown area, which included the subject property, lot 49 was identified as an unimproved vacant land that has remained so for a period of over 10 years. And based on review of historical photography, aerial photography, and other maps dating back to 2014 and beyond, it's confirmed once again that lot 49, as you see in the photos, remains vacant. In this case, it appears to have been vacant for at least 30 years, which well more than complies or comports to the redevelopment statute criterion C, which is prior to the resolution being sent to the planning board, it must be remain so vacant for a period of 10 years, in this case, 30 years. Additionally, there appears to be some challenges with being able to redevelop that lot in particular. As you can see, the property is landlocked. So it's not a matter of simply subdividing it and allowing a redeveloper to build on it. Subdividing require variance or planning variance because it lacks frontage on the street. If it were to be developed with the other parcels, there is extremely limited land available to put even a one-way driveway, but in reality, you need a two-way driveway and buffers to connect from the parcels that front on Meriden Avenue to get to the rear of lot 49. That means that it is not possible to provide for a driveway or parking for development on 49 without being assembled with other properties. And There's also a substantial grade change in the rear property of all historic Montgomery apartments. What this means is that even if it were to be subdivided and developed on its own, it being 50 feet wide means there's only about 30 or 40 feet available for development. And that just makes it highly impractical to be developed for a downtown setting, let alone a single family house on a typical 50-foot wide lot. So given the reason of its location, roadless, and lack of means of access to developed areas and topography, it is extremely unlikely that Lot 49 will be developed through the instrumentality of private capital. Ultimately, as indicated in the report, the land assemblage and effective redevelopment of Lot 49 as part of a larger comprehensive plan as contemplated through the Track A development plan, and for really the overall health of the study area, it will be more valuable contributing to the surface area if it were to be merged or consolidated into a larger redevelopment area and better serve public health, safety, welfare of the downtown area as well as the overall community. So it is with that finding that Block 49 in particular was occupied, again, occupies more than half of the overall parcel, half acre, that meets the criteria C of the statute. In terms of groundwater and soil contamination, the property is listed on the known contaminated sites list since 2013, according to the NJDEP records. Based on the records I've reviewed, and very little remedial investigation activities. Here's the property owners obtained several extensions and has changed its LSRP on multiple occasions. Based on prior activities that was identified between 2013 and February 2016, the borough engaged a LSRP, Upsell Environmental Resources, or I'll simply refer to it as Excel. They were charged to do environmental investigation of the study area, that is the Class Cleaners property. In 2018, a site investigation report, or an SIR, was published and was found that the study area had multiple areas of soil and groundwater contamination. The groundwater quality investigations entailed installation of 3 wells, and they all yielded a combination of various contaminants, including PCE. The report recommended that further investigation to determine the extent of the contamination, including a vapor intrusion study. As part of the development of that investigative report in 2018, background research showed that the LSRP for the adjacent Ruby's property as Environmental Alliance Incorporated, EAI, they identified PCE and TCE, which led the consultant to believe that the contaminants were migrating from the adjacent property because of the downhill condition. And the 2013 study showed that the PCE and TCE concentrations both exceeded the NJDEP standards detected in the study area, not just the Ruby's property. It wasn't until 2024, just last year, that an updated SAR report was prepared by the property owner's new LSRP. It did show that there was a reduction of contamination. However, compared to the sampling event back in 2018, there was still contaminations above the limits in the 2024 last year's report. So it's want to note that even though the business has stopped using even 20 years of ongoing cleanup shows that the property is there's still residual contamination from 2 decades ago, and the property is still contaminated. In conclusion, and in summary, there's 3 different criteria I believe the property hits on, and that is the vacant land, at least specifically to lot 49. Vacant land for at least 10 years. In this case, we found to be at least 30 years. So therefore, that particular parcel criteria C, due to a combination of various factors, including faulty range of design, deleterious land use, obsolete design, or other factors, including contamination. It's my opinion that the study area is detrimental to the safety, health, morals, and welfare of the community in accordance with criteria D. The reason I make that connection is to simply state that the property is inefficient in design. I also have to make a finding, according to the case law, that it is detrimental to the safety, health, morals, welfare of the community. And finally, because of the proverbial hole in the donut, what we found is that because the property is in the middle of the tract A development, this property fits with the really intended purpose of the definition of section 3 criteria, which even if the board were to make the finding that the property did not meet the findings as outlined in criteria C and D, it could rely on the section 3 criteria, which includes properties that themselves do not meet the criteria. So with that said, the various limitations of the study area, vacant land, alteration design, land use, and other factors related to health and safety issues. It is my opinion that the property meets criteria for condemnation or redevelopment. My recommendation would be that the Borough Council adopt the resolution, the planning board adopt the resolution, be forwarded back to the planning board, the Borough Council, and at that point, they could formally declare area redevelopment.
Thank you, Chris. All right, members, I'll open this up to discussion. Would anyone like to make comments or questions to Chris about his presentation? Let's go first. Alvin?
Yes, I have a question about the long vacant lot, especially for those of us who might not have visited that site or aren't familiar with that site. From some of the photos, it appears that it's directly adjacent to a east-west trending right-of-way or roadway. So could you explain what's going on at the north end of that lot?
So on the northerly lot line of lot 49, that is adjacent to the Highland Montgomery property. So even though it appears as a driveway leading into the garden apartment complex, that is not the Denison Street public right-of-way line. Public right-of-way line ends basically at the corner of lot 49, intersecting with lot 46. Public right-of-way stops there. So this lot 49 on its own does not have any frontage on public right-of-way.
Thanks.
Can you clarify which lots Borough currently owns next to lots 43, 46, and 49? Does the Borough also have possession of lots 48 and 47?
So the borough owns lots 48, 47, 45, 44, 42, and 41. Everything that's shown on the map there on the screen, except for the study area, lots 43, 46, 49.
Okay, and with the borough owning 48 and 47, which are right in front of 49, is the idea that those lots will be combined and made part of the tract A development plans?
Yes, it actually is already part of the tract A limits. So the classic cleaner study area is part of the tract A as of right now. But the goal would be to assemble all the properties into a cohesive single redevelopment project.
Okay. The other question that I have is regarding the contamination. So just so I'm clear, was the source of the contamination identified?
The source, I didn't get into the records of that. From my understanding, that is the site that exhibits contamination levels at that point.
And are there any efforts being made to remediate that?
The efforts, from what I can explain, is that back in 2018, the borough initiated an effort to be proactive to try to assist with funding from a grant to at least do the investigation, the preliminary report. That was back in 2017, report in 2018. I believe the property owner has since engaged its own LSOP to get an updated report from just last couple months ago. And that report shows still contamination levels. In terms of actual remediation efforts, there has been none.
Okay.
Do you mind elaborating a bit on which of the redevelopment statutory criteria you are saying applies to lot 43 specifically, the classic cleaners building specifically?
So lot 43, which would be the part of the lot, including the building, I would say would satisfy criteria B as well as section 3 criteria.
Thank you. Any other members of the board have questions for Chris before we open this up to the public? All right, seeing none, we'll open up The presentation to members of the public will start with attorneys who are physically present here with us this evening. How many attorneys are here in the public right now? Just raise your hands right now. Just one? All right.
I'm with his office. He's with them.
All right.
He's an attorney too, he's with me.
Fair enough. Well, if you could take the mic from Chris, and I'll let-
Is there, I guess there's enough time.
Yeah, if I could,
oh, there is another mic?
you should probably have two, right? Chris is gonna need-
I'll stay over there.
Can I address the board really? Chris?
Yes.
Can you identify yourself for the record?
Yes, please, thank you.
Oh, hold on one second. We seem to be having a technical back and forth. Let's just make sure we're all on the same page.
All right. Do we need another mic?
We're gonna get one.
Okay.
All right. Thank you very much, sir. Please go ahead and introduce yourself.
Okay, my name is Thomas Olson. I'm with the law firm of McCurdy, Riskin, Olson and Delapel.
Do you mind spelling your last name, please?
Sure, OLSON.
Thank you. Please proceed.
Okay, and I am here representing Bethel Realty, the owner of the property, as well as Plastic Cleaners, which is actually Mr. Thorland, your lingo, and I'm probably not pronouncing his name correctly. I apologize to you. But they are both here and present tonight. And we have previously submitted a letter objecting to the designation. As Mr. Cosenza indicated, this is an area in need of redevelopment with eminent domain, and that is a very severe impact on, obviously, on Mr. Lee's property, Mr. Erling's property. They do not wish to have their property condemned. They do not feel, and we do not feel that it meets the criteria. We had our planner here, expert planner, to present the testimony, and we have a report from him as well, which will indicate that the property and the criteria were not met. And we would like the opportunity to present that to the board this evening.
All right, well, do you want to elaborate on those points yourself, or do you want to call?
Well, I think we probably should cross-examine Mr. Cosenza first, right, Mr. Thomas,
Feel free.
and then I guess we'll present on.
Mr. Cosenza is behind you. Why don't you face
Oh,
it?
what, where are you gonna stand? Over by your laptop or? It's okay, I'm just gonna leave. I don't have a podium, I'm gonna leave my stuff here.
That's fine.
Thank you.
It's a public ticket.
That's very good. You stay there, you're comfortable there?
Yeah, good.
Okay, good evening, Mr. Cosenza. How are you? Good. All right, so Mr. Cosenza, you did the report that we are, that you testified to just a few minutes ago yourself, correct? Did anyone else help you with it?
I had staff in my office take points that I was explaining, basically dictating what to write on occasion, but I would say almost all the words are.
Oh, yours, okay. All right. I'm not sure you're.
Chris, I'm
Is
sorry.
it being
Just move a
amplified?
little
Yeah,
seat
yeah,
closer
there you
to
go.
the mic.
I have a
Thank
tendency
you.
to do this.
Yeah, we know, and we gotta keep it up.
Yeah, if you can repeat your answer, 'cause couldn't really hear again with the noise above here. So, yeah, who helped you? I'm sorry, who helped you with the?
I had staff in my office help me with writing as I gave each question, basically mainly on background information, including records.
Oh, okay, look into the records. Oh, very- Are you aware, Mr. Cosenza, that there's been a cleaner on this property for the last 75 years?
Yes,
And that Mr. Lee has operated a cleaner on the property since 1984?
yes,
And that currently there's a tenant operating a cleaner.
yes,
And I believe you indicated that with respect to this particular study area, the study area are only these particular 3 lots, correct? And that these 3 lots are all owned by Bethel Realty?
yes.
As a matter of fact, haven't the 3 lots actually been merged by the borough into one?
From, if I'm understanding the question correctly, it appears on one tax record card. Probably with lot 43 being the primary lot and lots 46 and 49 being secondary.
Yeah, as a matter of fact, here's I'm going to show you, it's just a copy of the tax assessment record.
Yes,
And it indicates that lot 43 is actually the lot. They've all been merged by the operation of law, correct?
yes,
And as a matter of fact, the property's been being assessed by the borough at $728,800.
Yeah.
I believe you indicated in your report that Mr. Lee, or Bethel Realty, they're current on their taxes. They pay their taxes, correct?
they are currently now,
Yeah, there are no liens, correct?
Not presently.
Yeah. Okay. Now, when you, did you get inside the building?
Yes,
Okay, it's a functioning dry cleaner, correct?
yes.
Did you get upstairs too?
I requested access to the second floor and the property owner, Mr. Lee, did not grant me access.
Because there's tenants up there, right? There are people residing in upstairs, there's apartments.
That's what was explained to me.
Two, right? Two apartments upstairs.
Yes,
And in addition, up on the roof, Verizon, I think, has a couple of cells up there, right?
yeah, 2 cell towers.
Two cell towers. That's the wooden stairs you mentioned before, those stairs are just for that, correct?
I don't know. Don't have on the roof.
Is there any other way to get up to the roof besides that?
I don't know.
Now, you mentioned that you did do a request for the record, correct? Relating to this property?
Yes, as I always do.
And indicated no liens on the property, correct?
I believe I put in my report, just let me jog my memory. Section 3. There are no open liens nor any liens that were redeemed for the past 5 years.
No zoning violations, right?
None of record.
No police report regarding any crime or other incidents at the property?
None of record.
No accident reports?
No.
I think you said there really was no records at all, right, about any difficulties?
So there was very limited information, yes.
I indicated the property itself, the building itself is in fair to good condition, right?
There were parts of the building, exterior and some interior that appear to be in fair condition.
But otherwise, see, the fair to good building is operating in a functioning building.
It functions, yes.
And I find you indicate you like the basement, right? Basement was.
I like that it did not have storage or food, as I often see with other sites.
Well, hopefully not, it's a dry cleaner. All right, so you indicated you're familiar with the case law that, as it relates to redevelopment, correct?
Yes.
Are you aware there's a recent opinion by the New Jersey Supreme Court, which kind of helped to clarify this area of the law and redevelopment, called Malanga versus West Orange? You familiar with that one?
Yes, I believe so.
Yeah, that's at 253 NJ 291, 2023. Now, that case indicates that when you're doing an analysis like this, and a study like this, in determining whether or not the criteria and whether or not it actually comprises an area of redevelopment, you need two things. One is sufficient proof that areas with buildings or improvements suffer from one or more specified conditions, correct? And then sufficient proof that as a result of the particular condition or conditions, the areas are detrimental to the safety, health, morals, or welfare of the community, correct?
Yeah.
So you need two things. You have to look at the criteria and see if they're met, and then that's not enough. They also then have to be detrimental to the safety, health, morals, or welfare of the community, right?
Yep, I believe I mentioned that in the testimony.
And you agree with that?
Yes.
Now, with respect to what we're talking about tonight, we are only talking about these 3 lots. That's the study area, correct?
Correct.
There are no other properties in the study area.
Right.
And with respect to the vacant lot, that you're using criteria C for that, correct?
Yes, vacant unimproved property.
The parking lot and the building owned by Bethel Cleaner would not fit into that criteria.
No.
I believe you, one of the criteria you've come up with is D, correct?
Yes.
Now, I think you indicated with respect to the parking lot, you mentioned some, in your opinion, you mentioned people coming in and out and whether or not there are issues there. How many people do you know have been injured as a result of that condition?
Given the lack of documentation of any accident reports, I can't say there is 0 or a lot.
But there are no accident reports indicating there have been anyone injured.
Nor were there any condition that would suggest there were not any,
Well, if there were, there would be a police report, probably.
potentially.
How about car accidents? Any police reports regarding cars having accidents in the parking lot?
None that were recorded.
I think you indicated that there's an obsolete design here. Is that one of the criteria that you've come up with?
I was relying specifically on faulty arrangement design or other factors.
And how is that, other than the fact that you've indicated this, that you have no other evidence with respect to how that's detrimental to the safety, moral safety, or welfare of the community? There are no other reports, and there's no other evidence that you can point to other than your opinion.
No other evidence other than using the actual site conditions and the observation.
Also, with respect to the building, which you indicates is in a functioning building in very good condition, some of the items that you've mentioned can be corrected, correct? In other words, the broken windows, they've actually covered them over now, correct? I mean, it's not, they're not, they put something across the breakage so that it's covered.
I'm not aware of that.
With respect to the stairs, they can be cordoned off, they can be repaired, correct?
It'd have to be completely reconstructed, yes.
Well, what are you basing that on? They're there and they're being used.
Well, given the wood rot condition and the lack of the guardrails on at the base of the stairway, so on the roof, there will be more significant work need to be done. I did also know that, I believe it's in the report, may not put in testimony that the first couple steps did not meet code in terms of that consistent riser rate.
Yeah, those stairs can be, that's an item or it's something that could be corrected, correct, fairly easily.
And the cost.
Yeah, the cost to the owner. And with respect to those stairs, they're only used by Verizon anyway, right? They're not.
I don't know who uses it.
And you mentioned the contamination at the site. The owner is, in fact, Mr. Lee is actually working with the DEP on this, correct?
That's my understanding now.
He has an LSRP.
Yes,
He's got monitoring wells on the property.
yes.
Are you aware of any violations from the DEP that he has not been complying with their plan?
I don't recall specifically, other than that deadline's been extended, and I don't think they're being extended any further. It's my understanding that DEP is assigned as a responsible party.
Yes, and he's been working with them. Correct. They haven't cordoned off the site, right?
Not as
They
of
they
yet.
haven't indicated to anyone that this is a danger to the public, correct?
Other than the contaminant levels, I haven't heard any conditions about closing off the property.
Okay. The property continues to function with the monitoring wells there.
With the wells, yes.
Just getting back to Malanger real quick. You aware of the section that indicates the municipality's discretion is not unfettered. The governing body must rigorously comply with the statutory criteria to determine whether property is in need of redevelopment, correct?
Yes,
And it says more than a bland recitation of applicable statutory criteria and a declaration that they have been met is required. It must contain the record must contain sufficient credible evidence that the designation satisfies the requirements of the LRHL, which is the statutes that we have been discussing tonight. And so, Mr. DeSanto, I'm sorry. So this has been, the property has been functioning as a dry cleaner for, I think we said for 75 years, correct?
when I spoke to the property owner, that's my understanding, yes.
Now, when we look at these, the redevelopment statute, and we look at the conditions. If you had a blank slate, I think you indicated this earlier. If you had a blank slate, you might develop it differently, correct?
Perhaps, yes.
But we don't have a blank slate. We have a property that exists. And in order for that property to be found in need redevelopment, it must satisfy the criteria.
Yes, at the then current conditions.
And this is, I think as you indicated, a functioning dry cleaner.
Yes.
Also, by the way, when we were talking about the dry cleaner, the area open to the public at the front of the building is just, it's a small vestibule area where people can come and bring their clothes, correct?
Yeah, there's a little bit of stuff up, so it's not accessible.
They actually clean the property, clean the clothes at this site.
So they clean the work.
When people bring their dry cleaning, it's actually done on the premises.
Yes, that's what I
I
understand.
mean, a lot of the dry cleaners today send them out. But this one it's actually done on the premises,
Right, the equipment's on site.
and they have equipment on site. And some of the areas that you indicated in the back that had maybe the restroom, the toilet back there, and the walls that were blocked and so on. That's not the part that the public traverses, correct?
No, but it's used by the.
The workers work there, yeah. The public, the area is finished off in a manner that you would see for most dry cleaners. There's a desk, there's a tile on the floor and drop ceiling and so on, correct?
Yes.
I have nothing, I don't believe I have anything further.
Thank you, Mr. Olson.
Mr. Olson, before you call your planner, I just want to clarify something from your questioning here. Is it your client's position that the 3 lots we've been discussing tonight should be evaluated by this board as a single lot, or each lot evaluated based on its individual merits?
I would ask the board to evaluate it as a single property. Because it's all owned by one, the borough has combined the lots. So I think if you wanted to, you could find that almost a portion of the property meets the criteria. But I think you can look at it either way. I would leave that in
It's not
discussion.
ultimately up to the board, will it not?
I would say it's up to the board.
Well, thank you.
Yeah, I thank you. And
If you want to bring your planner. up.
yeah, I would like to bring Mr. Steck if that's possible.
Mr. Who?
Mr. Peter G. Steck, he's different,
So you swear affirm testimony that you're about to give will be the truth, so help you God.
I do.
Would you be kind enough to state your name, spell your last name, and give us the location of your office, please?
My name is Peter Steck, S-T-E-C-K, 80 Maplewood Avenue, Maplewood, New Jersey.
Thank you, Mr. Steck.
Before Mr. Steck begins his testimony, I do have some extra copies of his report, if I can pass that
Well,
out.
it would have been nice, as you know, Mr. Olson, to have had that material in advance so that number one, the board could end up being in a position to review that, as well as Mr. Costanza and myself. So I really do have a problem, but yes, you can present it.
Right, and
There
again,
may
just,
be some issues
yeah.
later on that I have to discuss with
okay,
the
well,
board and the members.
just to explain,
Well, I don't need an explanation.
Well,
All I know, hold on.
Okay.
All I know is that the material is being submitted as of this moment, which is now 8:33 on the day of the hearing.
well, I would,
And it has not been presented in advance, and the material that you have had has been presented to the public for a considerable period of time.
Well,
So that's a problem from
well,
my
but
viewpoint.
let,
That having been said, why don't you proceed?
okay, and let me just indicate again, Mr.
I'm
Trump.
not so sure there's a need for indication. These are
Well,
facts that I think are.
Okay, but I want to
these-
explain to the
let me
board, I don't
finish.
want to.
These are facts that are on the record, and whatever your excuse may be, is your excuse.
It's
That
not an
doesn't-
excuse, Mr.
Well, that's your opinion.
Well-
The fact of the matter is that Mr. Steck is a planner, yeah, there we go. Is a planner that's been in the business for a long time. He understands the rules and he understands the fact that this was scheduled for today. And you and him decided that it was appropriate to end up having this report submitted to this board this evening at 8:33.
Can I, again, this is.
I'm not so sure you
this
can.
may- This may be
Why
on
don't
the
you
record
proceed?
before
Why
court
don't you
sometimes,
proceed?
Thomas. I'd
No,
like
I'm
to
not going to allow you to get into the discussion as to what the excuses are. Why don't you proceed with your planner so that we can have testimony? And you might want
We all,
to.
but my clients only just got notice of this hearing. It's 10, the statute says 10 days. Mr. Cisneros had a long time to prepare his report. Mr. Steck worked diligently and he completed it today.
The fact of the matter is that nonetheless, why don't you submit the report?
Yeah, thank you. And there's a few other copies for the.
Yes, that would be nice. Chris, do you have a copy of it? Of what? Of the Peter's report? If you don't mind.
I do have one more copy of
Well, let's see if we need another one.
They were short one. All right, Mr. Olson, why don't you proceed with qualifying your expert, please?
Yes, Mr. Steck, are you a licensed planner in the state of New Jersey?
Yes,
And why don't you detail for the board your credentials?
by way of education,
If we could shorten this, I'm familiar with Mr. Steck's background. Mr. Steck, you are a professional planner in the state of New Jersey, is that correct?
yes,
And in fact, your license remains in, I assume, remains in full force and effect in the state of New Jersey.
that's
And
correct.
you have testified before planning, zoning, and land use boards on many occasions, have you not?
Yes,
And are you licensed in any other state?
no,
Okay, I have no additional questions with regard to his background.
Okay, thank you, Mr. Mr. Steck, you
before we start, I have a memory stick, and I don't know if someone has which is better than my memory. And I don't know if someone has the capability of putting
You
it on
can
the,
ask our
Yeah,
qualified IT
Peter,
professional and
Peter,
then
I
actually
don't
move
have that
forward.
capability, but maybe he does.
I didn't ask you.
And then when you are prepared to start giving your testimony, please do remember to use the microphone.
This is the thing with that. Do you have like what Chris had, where you did the transition each slide?
Pardon? It's a PDF document on this.
Because it's a PowerPoint, right? You have to.
No, it's not, it's a Word PDF document.
All right, so but otherwise, you have to let me know when to turn it off, because I don't have access to it. You know what I'm saying? When you're done with the presentation.
Okay,
Well, this is, with all due respect, this is technical. I don't know that needs to be on.
But when they get back to.
When
the
they get on,
desk-
you're absolutely right. Mr. Steck will get the microphone up and it'll be no problem. Mr. Steck, get the microphone if you don't mind. Okay.
I'm happy to go through my report. There's some graphics in it that I'll describe. Here.
can we get it up now?
Try to get it up, yeah.
Okay.
Mr. Steck, let me just say preliminarily, while they're working through the IT issues, when you do go to give your testimony on your report, I would ask that we don't need to hear about every statutory criteria. Please focus your testimony on, as you're across to the factors that have been presented by the borough's planner. We don't need to go more beyond that. Which is my very respectful way of saying, let's try to keep everything focused, because I still have many members of the public who wish to be heard. We're being very considerate with the time here because you do represent the owners. So
Okay.
please proceed accordingly.
If I could, there are two items on the stick. One is a report and the one is a singular page.
No.
The whole report's there. but
What do you want?
Okay.
It's not gonna work.
Okay.
Okay.
Okay, hi, Mr. Steck, well, he's working on that. You've had an opportunity to look at the subject property, correct?
Yes, on several,
I already did.
You already did.
Thank you for that reminder, though.
yes, on several occasions I've looked at the property. So before you is a report that I prepared. It's dated March 6th of 2025. And it's entitled Planning Evaluation of Area in Need of Redevelopment Investigation, Classic Cleaners, and then identifies the property by lot and block and street address. The first page has a reproduction of the property as it is included in your planner's report. It appears to be 3 tax map lots. I talk about the statute, and the only thing I want to emphasize is the purpose of the redevelopment law is to address situations where the private marketplace is not operational. And that's in the purpose statement in 40 NJSA 40:12A-2. And this, as you know, is a condemnation area. So it's serious that while if you declare this in need of redevelopment, which is the same as declaring it blighted, the governing body at will can decide to condemn the property or not condemn the property. But from the point of view of the owner, the game's over. The governing body has absolute power to condemn the property. And the only argument is what the amount of just compensation
I
is.
apologize for interrupting your testimony in the flow of procedure. You've made some declarations on the state of the law. I just need to ask, Mr. Thomas, is that your understanding of the law as well?
Well, in terms of the fact that there is a provision under section 2 that deals with the issue of the market, but that's a broad statement, and I'm sure that we will get some clarification either by way of Mr. Steck's clarification or by cross-examination or by clarification from our planner.
Thank you. Please proceed.
Thank you. Again, the report, as I read it, separated the parcel into 3 tax map lots and in a sense analyzed them independent of one another, and particularly the rear lot, lot 49, was separated from the other properties in terms of its analysis. The applicant, your planner has invoked criterion C for that rear lot, D for the whole area, but really it's the parking area and the building, and then invoked section 3 that says if a property doesn't meet the other criteria, C or D, you can still include it if it's necessary for effective redevelopment of the area. An important consideration in your planner's report is that it specifically states we're not commenting on the plans that surround this property. The report says, you know, there are different plans, different developers interested. Those specifics are not involved with this investigation, and the report says that. So there's no specific plan, at least in this report, behind the scenes that says how this property would be integrated into a larger area. The report specifically discloses is we're not endorsing any other plan in the rest of this area that surrounds.
And Mr. Steck, that's because the study area is just these 3 lots.
Yes,
Right.
but also the plan, indeed, even if you want to look beyond the 3 lots, and as indicated, this is the one property that is not owned apparently by the municipality, but the answer is it is an important consideration that this document that your planner produced says we're not endorsing any plan for the remainder of the area, the larger area.
Right, and if the study area is just these 3 lots, then with respect to section 3, they can't be the hole in the donut because there's no donut.
In this case, there's no donut because the study area is just this property. But if you want to go global donut, there is no endorsement of a plan, which in my opinion is important. This as a conforming use, this is controlled by an older redevelopment plan, permits personal services, it permits residential. So these are conforming uses that are on the Classic Cleaners property.
Pause for me for just 1 moment. Chris, this area is part of the Tract A redevelopment plan, correct?
Yes, since 2020.
Including the energy study and the surrounding properties.
Yes.
All right, so not to interrupt your attorney's questioning, but how do you respond to the idea that there's no redevelopment plan? They're all part of Tract A of the borough's redevelopment plan.
There is no, there are guidelines, but there's no specific site plan approved for the entire area. It's flexible.
So is it your testimony that there would have to be a site plan actually developed and in place in order to find a hole in the donut for redevelopment planning?
In my opinion, and we're jumping the gun, I know I wanted to go through this in a logical fashion, but to invoke criterion 3, you have to say that this property, this study area of Classic Cleaners is necessary for effective redevelopment of the area. And if you had a plan that said, there's going to be a 20-story high-rise here, et cetera, and there's 100% lot coverage, one might argue that it is necessary for effective redevelopment. But this study says, ignore the plan. It says we're not voting on the plan. We're not picking one plan over another. So that flexibility is important, in my opinion. I read the report, and there are a number of items which are, and I'll talk about the phrasing later, that were with speculation. There are phrases, I'll just give you samples of them. It talks about the roof is entering a state of disrepair. I don't know what.
Mr. Steck, you're referring someplace in your report. Maybe-
I'm jumping to page 14. And rather than part of my report recasts or emphasizes certain portions, let me back up. This business has been here for a long time. It's a very active business. It tends to, people drop stuff off on Monday. They pick up their clothes on Friday. On a typical busy day, you have 50 to 100 transactions. So if you're interested in having activity in your downtown, boy, this is it. You get a lot of activity here from this facility. What has happened over time, and I'm sure some of you may be aware of it, is that other dry cleaners have disappeared. Over the past 10 years, they disappeared from New Brunswick. The number that were in Highland Park have disappeared. So people like convenience. They like a dry cleaner that's in town. And this is one of the few that's left. I want to emphasize that while you need a parking area because people don't walk that far with clothes hangers, you need to deliver your clothes, this is a very active use and well used by both people in Highland Park, in Piscataway, in New Brunswick. It's a very active use. And if one of your goals is to keep activity in your downtown, this is a pretty decent use, in my opinion, if that is the goal.
Mr. Steck, is it also your opinion that the current parking setup isn't effectively services such a busy business and residential unit as it is right now?
Yes.
In its current condition, despite the testimony you heard from Mr. Consenza that there's no ADA accessibility and there's only 3 to 4 usable parking spots, you feel that it is sufficiently serviceable for 2 apartments
and a very busy, active business.
Yes, and I'll go into the details.
I would like to hear how 3 to 4 parking spots sufficiently services that business.
It's because it's not just 3 to 4 parking spots.
Okay.
So if you'll wait, I'll get there. On page 14, so my first conclusion is that these 3 tax map lots are one lot because they're substandard by themselves.
Okay, we're gonna pause again for a moment. I'm gonna ask your attorney. Does the applicant want us to consider all 3 lots as one lot, or is it up to the discretion of the board if we treat them as 3 separate
Well,
lots?
I think if I can, he's already indicated it, it's the board's discretion to be able to do that. And I understand that Mr. Steck's opinion is that it's one, but it's up to the board to make that determination. And I think the board should retain that flexibility. So why don't you proceed?
So your tax assessor thinks that this is one property. And he gets one tax bill. The 3 lots all have the same ownership. On your records, it is one lot. And in fact, this lot is assessed in a 4A criteria. It's commercial. And in fact, if you read the definition of commercial, it excludes vacant land. If you have vacant land, that's not commercial. That's specifically part of the statutory definition. So the borough considers this one lot in commercial use. In my opinion, those 3 tax map lots have merged because by them, they're in common ownership and each by itself is substandard. One lot has just the building with 0 parking and you require some parking. One lot has just the parking lot as a then it would be a principal use rather than accessory use, which doesn't make sense. And the vacant lot that's called vacant lot, that's part of the whole parcel in the rear. This is all one property. So because the borough looks at it as one property, because the case of Lochner versus Campoli suggests that it's one property, because it's used as functionally as one property, it is one property. And consequently, you can't say the rear yard is vacant and you can't get there. It's not vacant. Your assessor says it isn't vacant. It's part and parcel of the open space of this property. And so, in my opinion, you can't apply criterion C to this because it applies to vacant land that is like remote from the developed portions of the municipality. You can't get there. What you can do is just walk there. It's in the back of this property. The second point I want to focus on is the application of criterion D. And as indicated, that was recently clarified in the Kevin Malanga versus West Orange case, where, as I understand it, the Supreme Court said, you have to, first of all, identify what criteria. Is it deteriorated? Is it obsolescence? Well, it's not obsolescent because it's used. You have to first identify the criteria that are present. And then, as an important feature, how is that detrimental to the community? What's the harm to the surrounding properties or the community in general? And first of all, there were observations made, and I put these in the middle of page 14. And I would call these speculative observations. It says the roof is entering a state of disrepair. I don't know what entering is. I was up on the roof. It looked great to me. It said a downspout may potentially be contributing to water damage. Well, if you can take someone's property because the bend at the bottom of the downspout isn't there, I don't think that was the intent of the legislation in terms of being able to condemn someone's property. The answer is the water splashes down on the ground and it might discolor the building, but it's not detrimental. And in fact, it's easily fixed with probably $1.50 and an aluminum elbow on the downspout. The report says there's potential mold. I don't know what potential mold is. That's not mold, that's potential mold. There's suspected asbestos because of the age of the building, but we don't know if there's asbestos there or not. It's suspected. There may be lead-based paint. Well, no one's tested for that. There's no proof that it's there, but it's there. It may be. It talks about the bathroom appeared to be substandard. Now, this property has had inspections periodically. The certificates are up on the wall and they're in my report. He's got his business license. He's got a boiler license. There are no violations at all in any of the codes that are outstanding. Your planner says the lot layout may result in driver confusion and poor visibility. It may result. So we don't know if it does or not, but it might, and I'll talk about that in a minute. And it says broken windows constitute a safety hazard. Well, there are some cracks in the windows. Some of the windows at the lower level, they're wire glass, so it's not like the glass is going to fall out. There's one window that has a panel behind it. So this is not a broken window where the air is blowing in and out of the building. The answer is there is a cracked window there. So number one, those speculative comments, in my opinion, are not substantial, credible evidence. There's misinformation. It talks about the a unused air compressor. The air compressor in the basement is used because that's how you power the pressing equipment on the second floor. There was an oil spill, and if you look carefully at the picture, there's granular matter put on it to soak it up, but that's part and parcel of how these things operate. There was talk about the curb cuts on Raritan Avenue. And it said, oh, they're too close and they don't meet like some 32-foot stand. I don't know where the 32-foot standard came from. But if you look at the curb cuts, starting from the automotive shop, there's a curb cut of about 21 feet in width that I measured this evening. And then there's a middle area of about 21 feet, which is actually a parking stall. Cars parked there, and in my report, you'll see that. And then the next curb cut is about 19 feet. There's nothing wrong with that. In fact, it's great that you have separate entrance and exits. Now, the pavement has been recently redone. The lines are striped. There is not a handicap sign, but the parking space next to the building would be logically the handicap one. And in fact, there's enough room to have a full handicap place. So what's missing is the handicap sign, but the dimensions are there. I measured this evening the distance from the guardrail to the closest part of the building. Now, keep in mind, there's right angle parking. So you have a standard 18-foot parking space, and then a 24-foot aisle. So you could have this parking arrangement with a 42-foot distance. The distance from the guardrail is 50 feet. So you got an extra 8 feet to turn around in that aisle. These are highly functional parking spaces. The parkings, as I was there doing my inspections, there was someone parked in the parking space right next to the building. They didn't back out over the sidewalk. They backed up 5 feet went into the aisle, turned around and went out the correct way. You don't have to back up over the sidewalk because there's luxurious room here. Again, there's a 50-foot distance between the guardrail and the building. That's more than enough to have right-angled, single-loaded parking. Now, your planner says, oh, there's no landscaping there. There should be a buffer. I don't know what you're going to buffer, the guardrail. That's my client's guardrail that's there. So apparently we're deficient because we don't screen the guardrail, or we're supposed to have wheel stops in the parking lot. Why would you have wheel stops if you have a guardrail? Doesn't make any sense to me. So these criticisms of the parking area, in my opinion, are unfounded. I would say that there are functionally 8 parking spaces here. And there's more than sufficient aisle to get in and out. And there is more than sufficient dimensions for a separate driveway entrance and exit. And by the way, there's no evidence of any accident, any pedestrian accident, any car accident on the property. It operates, in my opinion, very well. Let me get down to the end here. So just to remind the board, under the Malenga case, you have to show actual harm to the surrounding area. So what's the harm? No violations, no accidents, nothing falling down. The first step in the rear of the building to go up to the roof for the Verizon, the first step doesn't match the other steps. I could go there this evening and make that the first step, but the answer is the only people that use that stairway are associated with the Verizon equipment up there. In fact, there's a sign as you walk up there that says what you can and can't do because of the Verizon equipment. So limited use of that access point. I climbed up there. You're right, there's not a guardrail or a parapet all around the top of the building, but the answer is the only people that go up there are Verizon people. And there are cautionary notes as you climb the steps and are at the top of the building. The final issue is the application of criterion 3. And let me emphasize what that says. So that's not the criteria A to H, as you know, that's in the definitions section of the municipal land use law. And it says, as used in this act, unless a different meaning clearly appears from the context, and this is definition Y, a redevelopment area, shall mean an area of a municipality which the governing body thereof finds is a blighted area or an area in need of rehabilitation whose redevelopment is necessary to effectuate the public purpose declared in the act. And here's the important sentence. A redevelopment area may include lands, buildings, or improvements which of themselves are not detrimental to the public health, safety, or welfare, but whose inclusion is found necessary with or without change in their condition for the effective redevelopment of the area of which they are a part. If your planner says that Section 3 applies, that implies that none of this study area meets any of the other criteria. That's the purpose of 3, is to say when you don't meet the other criteria of obsolete and detrimental, when you don't meet those, you can include a good property in the area. So by saying that Section 3 applies, at the same time, the applicant is saying, well, it only applies if none of the other area is blighted. And it's almost an admission, I try to apply that none of the 3 components here are blighted. Because the report clearly does not endorse any specific plan for the larger area, it is impossible, in my opinion, to conclude that this property is necessary for effective development of the study area itself, which I think was the intent of the state legislation. But if you want to expand it, there is no evidence that it is necessary for effective redevelopment. And again, here's the burden of proof is on the planning board and its planner. And you want to have substantial credible evidence. Here's the substantial credible evidence. Your planner says that section 3 applies. Here it is. Because it fits within the intent and purpose of section 3 criteria at NJSA 12A-3. So the substantial credible evidence is that this property is necessary because it meets the intent. In my opinion, that's a net opinion. There's no basis to say that. There are no facts. And in fact, the report says we're specifically not talking about the rest of the area. So in summary, I don't think this board has substantial credible evidence in front of it that would allow it to conclude that the study area qualifies as an area in need of redevelopment.
Thank you, Mr. Steck. We have none.
Did any members of the board have any questions for the property owners?
Couple of questions. Just taking through your thinking, so Mr. Costanza gave his testimony, explained the history of this area and the steps that the borough has taken to redevelop the area. And it's documented in his report. And it's the first front matter, it really goes through page 18. And I'll say in 2020, and Chris, you need to correct me. We did make recommendations to condemn or have a redevelopment area designation that for the gunboat, that would be gunboat storage, that would be an area in need of redevelopment with condemnation in 2020. Then we did, that was 2020, and then 2021, we also adopted a redevelopment plan for that entire area of the Gateway and Area A. And so the planning board has heard testimony and has heard a lot of it actually for that whole area, right? We have looked at that area, the whole borough. Before that, this area was in a rehabilitation area. So that's context. I think that is part of that all goes into and leads up to tonight's review of the preliminary investigation for these three properties, right? I'm not sure what position you're taking, and sometimes I hear you say, well, we're only looking at these three properties or one property, however you want to play it, or versus well, the other, we didn't look at the whole area. But in fact, we have looked at the whole area, and I don't think it's uncommon for municipalities when they do redevelopment to look at a whole area and take piece by piece by piece, while always in context understanding a larger area of which we're working. So it seems to me, and I think you want it both ways. I think you, on the one hand, are saying, well, only tonight you looked at these three properties, so the planning board cannot consider anything we've talked about or voted on for 3 or 4 years prior, or 5 years prior, or 10 years prior. And then on the other hand, I don't know what you mean actually, but I'm sort of feeling a shell game going on, here.
Okay.
So why don't you explain?
Here's why it's not a shell game. When the state statute was amended to have condemnation and non-condemnation areas. That was a big change. And when you're changing an area from a non-condemnation to a condemnation area, I think the legislature recognized that's serious stuff because we can take your property. Despite whether you want to sell it or not. And so my understanding of the intent of the legislation is you start over again when you're turning this into a condemnation area. Now, what's weird is the criteria are just the same. So I think people have told me that there was a concern that you declare an area in need of redevelopment without condemnation. And of course, the property owner calms down because you're not going to take his property. And then he come in next year with the exact same testimony and said, look, you just concluded it. Now we're going to turn it into a condemnation area. It's a whole different, number one, it's a whole different ball game when it's a condemnation area. Number two is the focus is on the word necessary. You have to have this. You can't do it without it. And one of the, I'm glad that your planner hasn't invoked criterion H, because that's, first of all, there's no law or regulation that says what smart growth principles are, but what that is, it's future oriented. It's what you would like to see this property. Your planner would like to see parking islands and, concrete curb bars and landscaping. I would too. But that's not the criteria for a blight. In fact, there's a case called Spruce Manor versus Belmar that says the very fact that you don't comply with zoning standards is not dispositive of whether something is in need of redevelopment or blighted. So my point is that the burden of saying it's necessary, first of all, I think the intent of the legislation is to just look at the study area.
Section 3 now.
Section 3. Okay. Most redevelopment areas are not single properties. Some are. But if you had 10 properties, and again, 8 were clearly, met criterion A through A, B, whatever they were, and you had 1 property that did not meet it, then there's a judgment. Is it at the edge of the area that can be extracted? There's a phrase, is it the hole in the donut? If you'll go to Montclair on Upper Bloomfield Avenue, you'll see a building that was built around a Japanese restaurant. Because while it was there, it's like the hole in the donut. The answer is it wasn't necessary. So my focus is what you would like to see in the area does not necessarily answer the question of whether it's necessary or not. If there was a redevelopment plan that said, you've got to build 100% lot coverage and potentially you look beyond the study area, I suppose you could, I'll call it, fabricate an argument that it's necessary for the larger area. But I think the standard is stricter than that. Number one, I think it was intended just for the study area. And unfortunately, you have a 1 property study area. And that's why I say it's inconsistent to invoke Section 3, because Section 3 implies that it's not blighted to start with. So you can't go to an area and say it's necessary if none of the properties are blighted.
One of the things, and I guess maybe, our council can counsel the planning board, but I don't think it's uncommon for municipalities to look at an area and break it up into smaller pieces and tackle smaller pieces one at a time. And I don't think that precludes the planning board or the borough to then say, well, you started with a larger area, and the minute that you moved away from taking it all of one bite, you've now prevented yourself from looking at the area and taking into larger considerations. The planning board has looked at this
area for years, right? We took one bite out of it in 2020, and that was the gun and boat store. Now we're moved out, now we're moving to this area. And for some reason, because we didn't take it all in one full swoop, we are now unable to use section 3. I don't buy that argument. I don't think that makes sense to me.
I understand. Let me ask a couple of questions. Are you finished, Jim?
Oh, and then you tell me I'm finished and I'm.
Peter, let me ask you a couple of questions. You don't dispute the fact that there is a redevelopment area that incorporates this property.
Your microphone.
Oh, sorry. I was talking to Peter directly. I didn't mean to. Anyway, the bottom line is that you don't dispute that this is a redevelopment area that has been designated by the town, correct?
Correct.
Okay.
It's tract A, whatever.
It's tract A. That's exactly right. And in fact, as Jeff has made reference to, there have been any number of discussions over the years with regard to this tract in terms of development potential, correct?
Yeah.
Are you aware of that?
I've seen a diagram that keeps this property and then surrounds it with two buildings on either side. That's evidence that you don't need this.
Well, that's interesting. I haven't seen that. But the bottom line is that you would agree, based upon, and I'm now talking about your report, page 1, which ends up having the area. And you don't disagree that in fact, at least as part of tract A, that includes lot 41, correct?
Yes.
And it includes lot 42, correct?
Yes.
44,
Yes.
45,
Yes.
47,
Yes.
and 48.
Yes.
Okay. And you would also agree that and I will represent my understanding based upon discussions with Mr. Cosenza, that all of those properties are now municipally owned. You understand that as well?
Yes.
Okay. So when we look at, and then you made reference to the Montclair area where there is the Chinese restaurant that is on the
It was
edge.
Japanese,
Oh,
but
sorry.
anyway.
Sorry. Either way, I don't go there. But the bottom line is that that was, as your example pointed out, that was an edge property, and they then found apparently that in fact it was not the hole in the donut.
No, that was,
It was an edge property. That's what you.
well, I gave an
Isn't that what you
example.
testified?
No, I didn't say that was an edge property. I said that's
But it
the,
was on the edge of the
No.
redevelopment area.
the redevelopment area, as you face that property, is to the right, to the left, and behind.
Okay.
Exactly the same as this one.
So, but the point is that, well, is it really? Because the fact of the matter is that you have this property effectively surrounded by municipal property, do you not?
No,
Well, do you not have 48, 47, 45, 44, 42, and 41, that all of that property is surrounding your client's property, and whether you call it 3 individual lots or you call it 1 lot, it is still surrounding your client's property, is it not?
it's not technically surrounded because there's nothing behind lot 49.
Well, but in terms of its development potential, it's smack dab in the middle of that redevelopment area, is it not? Is it not?
If you concentrate on the road frontage, it is in the middle of, from the left to the right.
Thank you. So therefore, if you assume that it is in the middle of the property and therefore you end up having development, it is not unreasonable, although you may disagree, it is not unreasonable to conclude that section 3 does in fact apply, because in order to develop the property, you need to have the entirety of the property, as was concluded by Mr. Cosenza. That's not an unreasonable position to take, is it not?
I think that it does not arise to the meaning of the word necessary. You can have a project to the left and you can have a project to the right, and they both can be successful without taking at least the building and the parking lot.
Well, you know,
In my opinion.
So now you're saying that you're conceding that at least lot 49, whether it's singular or multiple, is something that can be taken. I think that's what your implication is.
I'm not conceding that because I
Well, you
don't,
seem to just concede it.
well, if you'll let me finish.
I thought I did.
I did not, because it has to meet the statutory criteria. Now, after tonight, there might be negotiations. That's not my business. My business is to listen to the testimony and to see if it meets the statutory criteria. I do not think it does, because that's not an isolated lot that's vacant.
Well, it is still a lot that is vacant, and your suggestion, and your counsel has already indicated, it's really up to the board to make that determination as to whether or not it's an isolated lot. And you've already conceded that it is a vacant lot, and it has been a vacant lot for a considerable period of time.
I have not conceded that it's a vacant lot.
49.
I said that this whole property is assessed for a commercial. And you can't assess it for a commercial if it's vacant.
Well, you're not saying that, in fact, there are situations in the state of New Jersey where tax assessors make determinations. They are not binding upon land use decisions, are they?
No,
You're not aware of any case law that would say that, are you?
I am not.
Okay. So the mere fact that that happens to be assessed as such does not then bind this board to say, oh, well, we're stuck, we can't really do anything. Correct.
The answer is this is all one lot, whether the tax assessor treats it that way or not because of Lochner versus Campoli,
In your opinion.
in my opinion.
And now you're suggesting that there is no possibility that an alternative argument can be made to say that when you have a Section 3 argument saying that it's the hole in the donut, that's an additional argument over and above arguments that may suggest that the criteria A through H are also present on a lot. Are you suggesting that that is impossible to do?
There are many opinions from different points of view. All I'm saying is based on the testimony I've heard this evening and the report, I don't think Section 3 can be applied here.
Well, that doesn't answer the question.
That wasn't your the testimony I've heard so far is that, in your opinion, if one of the A through H factors applies, you can't use Section 3.
No, I didn't say that.
Okay, well, you certainly implied that. So now you're saying that in fact, it is possible, as I suspect the law concludes, that in fact, you can end up having alternative arguments, which include the fact that a piece of property is both subject to the criteria and meets the criteria of A through H, whatever they may be. Let's forget about H because we know that that's kind of useless. But the fact of the matter is that it can meet those one or more of those criteria, and it can also meet the criteria of Section 3. And now you're agreeing with that.
I'm saying the argument can be made. I don't think it applies in the facts of this situation.
That's okay. That's my understanding is that's your opinion. I get that. But at least you agree with me that we can have alternative arguments about that. And I think you've already answered that question. So,
and Ms. Thomas, and again, I think what our position is, and I think Mr. Steck's testimony is that with respect to Section 3 and the hole in the donut, there really is no evidence.
Are you testifying as a planner or
as legal?
Oh,
As
a legal.
as an
Okay,
attorney.
well, we'll get to you in a minute.
Okay.
Let's finish up with Mr. Steck.
Very good.
All right, well, is there any other members of the board who have questions for
Sorry.
Mr. Steck?
I would just like to make a point that this board is made up of people that live in town, and we should be the ones that have the most interaction with the witnesses and things, and it gets frustrating sometimes. So let me just make a very simple.
If you're saying that I asked too many questions, I'll stop now.
Yeah, no, and Roger, we go way back, but it happens a lot. I mean, attorneys go back and forth, and I think the public suffers because of that.
Okay.
There's a lot of wisdom on this board, and everybody on this board lives here and has a vested interest of doing the best for Highland Park. So just a quick question. I come from a builder's background. What labeled here is lot 43. That's where the building is. That's where most of the tax revenue is assessed for the town, and that's where most of the revenue is generated with the adjacent parking lot. 43 and 46 are basically where most of the taxes are levied, where the revenue for the property is generated. So to me, I don't understand the value of 49 only as a hindrance to redevelopment. And that to me is doesn't fly. So that's just a very simple statement on my part, and I think it makes things clear.
And I think the market condition, I think this property has more value as a hindrance to redevelopment rather than in its own operating business. And that's something, that obviously, you have to balance out the rights of the individual with the town and everything, but it just seems to me that this is all about money.
Thank you. Go ahead.
I got just a couple questions here. So as we kind of mentioned earlier, we didn't see this report ahead of time. So I've just been kind of flipping through it here as we've been talking. So I haven't had time to read every word. But I didn't see, as I was going through it, any mention of the contamination on site that's mentioned in the other report. Was there any mention of that in here at all?
I summarized your planner's report, and there's a lot of stuff about contamination, but at the end of the day, it's in the process of being cleaned up, and it continues to be cleaned up. In fact, the test well that's on lot 49, which I think is, I forget the number of the lot 49 portion. I believe that's clean. The others, they're not clean yet, but they're in the process, and it takes time. It's not like there's a big, something pumping groundwater out of here. It has to biologically work. The answer is the DEP is monitoring this. It's getting cleaned up. It will be cleaned up.
So the remediation currently is in process right now.
That's correct.
In process.
And in my opinion, it is not a factor to determine whether this property is blighted or not, because the owner is responsible and it's being cleaned up. And if
hang on, sorry, you don't think it's a fact? So the chemicals that have been documented on site are mutagenic and carcinogenic.
yes,
Are any of those chemicals still currently in use on the site? I know there was one that
no,
was mentioned.
for
that
for
was-
more than a decade, my client was one of the early ones that abandoned those chemicals. So that it hasn't been used for years and years. He's very knowledgeable about that.
And just to be clear, it's your position that you just said that the presence of the chemicals on site shouldn't be taken into consideration when the standards that we're considering are detrimental effects for the safety, health, and welfare of the community.
There is nothing detrimental about the use of the site today. It is being cleaned up, and it will be finished and cleaned up, but it's not like someone dropping off their dry cleaning gets exposed to this. This is all groundwater.
Right, what's the timeline on the remediation? Well, actually, let me ask, how many times has the deadline been extended for the remediation?
I know that the applicant switched LSRPs. It was my understanding it was a question of cost, because someone had a much more reasonable figure than another contractor. So not being crazy, my client picked a more reasonable cost.
So do we have a?
I don't know. I don't know what it is. I don't know what.
Because it's been 12 years since the chemicals were first identified. We've extended.
All I can tell you is my understanding is one of the wells is now clean. The others are not clean yet, but they're in process.
They're in process. Okay. And again, I want to emphasize, it's been 12 years since the chemicals were first identified. There've been multiple extensions of the deadline and a switch of the, I don't know the correct term.
LSRP.
The LSRP, the contractor that's doing the remediation. And that was specifically because of the cost of the original one was too much, and now we're using a less expensive
And
one.
COVID had to do with it also in terms of people coming out and monitoring, et cetera. That was a factor in the delay, frankly.
And these are chemicals that, again, in the groundwater, right? They're not above ground. It's not like radon in basement. It's in the groundwater, which is not then limited to the site. So do we know the degree to which these chemicals have leached into the surrounding areas, including the downhill residential areas?
I do not know that.
Do we think that could have an effect on the, I don't want to get the phrase right, the safety, health, or welfare of the community?
All I can tell you is that it's being cleaned up and DEP is monitoring it, and we're not in violation of any standard.
Any other members of the board? Matt?
What are the remediations that are being done? How is it being remediated? What are the actions that are being taken to remediate?
I'm not the expert on that, but the answer is there's a licensed professional that is hired and is monitoring it, and DEP is completely aware of what's going on.
But as far as you know, there's no actual proactive steps to do remediation.
I think it's being done the way it should be done. But it takes, part of the process is it simply takes time.
Well, hang on a second, if we could just go back to that then. Is it a passive process, or like, is it we stop using the chemicals and eventually they'll all just leach away?
I'm not aware of this. I'm not an expert on that treatment.
Can anybody testify as to whether there are active remediation things going on, or is the remediation basically we stop using the chemicals and over time it will dilute because it washes off in the groundwater into the surrounding community?
Hold on, I don't think that's a question for Mr. Stecker. I think
Fair
it's a
enough,
question
but-
for Mr. Olson. If he's had anyone here who can
Fair
testify.
enough, if somebody can answer that, that would be useful to know.
Maybe in fairness, I think that's, I don't know that I want just anybody to answer that question.
And for someone who knows,
Correct.
professional type, yeah.
I just want to just on this point a little more. Chris, thanks for your report here on document on page 46 under prior activities with the groundwater and soil contamination. You note that since from 2013 through February 2016, there was no significant remedial investigations. Then you talk about how the borough took initiative to start the process, and that was part of the redevelopment agency when it was independent, and I was a member of the redevelopment agency. When we did reach out and got help from the borough to get Excel Environmental Resources. So truth is that if it weren't for the borough's initiative, I'm not sure any remediation would have taken place. It took the redevelopment agency at the time with borough funds to go in and get a grant from the county, I believe, to get money to actually do the remedial, the site, the records review and the site walk. Short of that, I don't think anything would happen.
Excuse me, can I say something?
No, not right now, you
Not
cannot.
right now, okay. Because
Is that your plan?
That's our plan.
because,
The answer is no, sir, you cannot say anything.
because I wanna say.
Just, sir, you cannot right now.
All right, any other members of the board have questions for the planner?
Yes.
Oh, yes, thank you.
Mr. Sheck, thanks for coming to the property and having a look around. I'm glad you weren't hurt on these stairs that might be dangerous, might not be. What I'm curious about is how many visits you've made to the site.
It's only 2 visits.
Okay, what times of day were those?
One was before I came to this hearing, I was there, and then Friday, the 28th, I was there for maybe 2 hours.
Okay, were you there during a time when people were walking on the sidewalks?
Yes.
Okay, can you be more specific about the times?
It was midday. When I got there, the parking lot was full. And then some people left. But I was there on the site. I toured inside of the building. I talked with the owner. I walked the neighborhood. I walked to the back street down the slope. So I would say I was probably there for a total of 2 hours.
Okay, around midday on that.
On that Friday.
Okay, and then you were here today in the evening?
Before this meeting, yeah, I went to the site to measure dimensions of the parking lot and the driveway aisles.
All right, that was during the daytime, though, daylight?
No, it was getting dark.
Okay, so you weren't there, say, when like maybe 20 minutes after the high school was getting out of school?
I was not.
Okay, or like you weren't there in the morning when people were walking their kids to school?
No, I wasn't.
Okay, you haven't seen anyone have a near miss from a car exiting that park?
No, there's clear visibility. Your planner's report says that it looks like a 50-foot wide curb cut, but actually there's a tree in the
Right,
middle.
there's a
It's-
tree. So if you're turning right from the parking lot, and I think when I was looking at the parking lot diagram, there's an arrow on the east side for in and an arrow on the west side for out of the parking lot, right?
That's correct.
So if you're turning right, you have to place your car before entering the roadway in a certain spot to not, well, like anywhere but a certain spot, to not have your vision be impeded when you're looking, let's say, left, to make sure that you're not going to cut someone off when you pull into the road, right?
Well, when the enter driveway is at an angle and you have clear visibility into the parking lot, when you exit, you're furthest away from the building, so you have a great view up and down the street to see where the pedestrians are.
Well, I'm not sure about a great view, but I will say that because it's an
Alvin, use
angle.
your mic.
Yes, sorry about that. I feel like everyone's forgetting today. So because of the angle, let's say this is the road right here and I'm in my car. I would be looking, my car would be pointing that way, not
Well, okay,
straight towards the road.
you're, just so that, so the record's clear, you're saying that you would be pointing in the right direction.
Yes,
Right
at
versus
an
left.
angle to the right, so that people would have to essentially look over their shoulder a little bit to make sure they're not cutting someone off when they're merging into traffic.
I don't understand what you said. I'm sorry.
It's at like a 40, in the driveway, the exit driveway, it's at like a 45-degree angle to the road. Give or take.
It's not a right angle. It is an angle.
Yeah. And
Right.
I think that's the point.
Yes, and there's also a tree in the middle of that view.
Yes, with
So, look behind you.
branches 15 feet high. You're right.
Yes, look over your shoulder and try not to like have the tree block your view.
When I entered and exited the site and walked around it, I didn't see any, I mean, there are issues if someone parks on the roadway, but that's true with any driveway along Raritan Avenue. Because you have on-street parking, that does some blockage, but the configuration of the parking lot with respect to the building makes sense, because when you enter, you can concentrate on pedestrian traffic. And when you exit, you're further away from the building, so that you have the best sight distance up and down Raritan Avenue when you're exiting the property, which I think is the correct configuration.
Okay. Do you regularly approve driveways of that width?
That's a standard width. I don't know, but in the planning report, there was something like the driveway's got to be 32 feet apart. There's no source. I don't know about that. I haven't seen that. The answer is this property could probably operate with a combined driveway of 20 feet wide. This has a luxurious width. It's about the eastern driveway is about 9 feet on the curb cut, and the other one, and then you got to go 21 feet to get to the other driveway. I think it's safe that you have that separation and you have that wide driveway.
Thank you for your testimony.
All right, any final comments from members of the board? All right. Oh, sure.
I actually have a couple questions for our planner.
Yes, well,
Let's finish with this
yeah.
planner, then we can call Chris back. But what I'd like to do is, I believe the board members are done with your planner, sir. So I thank you for your testimony.
Thank you, Mr.
Appreciate
Shea.
it.
Did you want to give the public an
Oh,
opportunity?
yeah,
to-
we're starting, that's what's next.
Yes, what I wanted to do was just ask Mr. Olson if you wanted your client to provide testimony, because I don't want to open this up to members of the public until you've had a chance to put on your full
Right,
presentation.
yeah, just give me 1 second. Thank you.
My plan is once Mr. Olson's done, we can hear from Chris and members of the public. Okay.
Unless he's got some credentials.
I mean, he can't speak to the technicalities of it unless he's got the credentials to do so.
Sure. Sir, do you swear or affirm the testimony that you're about to give you the truth, so help you God?
Yes.
Would you be kind, have a seat.
Okay.
Would you be kind enough to state your name, spell your last name, and give us your address?
Robert Lee. Robert Lee, yes.
Thank you.
And
Mr. Lee, let me ask you a few questions. So, Mr. Lee, you are the principal of Bethel Realty,
yes,
and you own the 3 lots that Bethel Realty owns the 3 lots we've been talking
Yes.
about. There is some questioning, and you've been here, about the environmental remediation that's going on the property. Why don't you explain to the board?
Yes.
Mr. Olson, I'm gonna have a problem with this.
fact of the matter is that, with all due respect, Mr. Lee has not been qualified to testify with regard to anything involving remediation. So if he wants to testify.
He can testify to the facts, as to what's,
Well,
his understanding was the owner.
See, he's now showing us some papers, which are not going to be terribly helpful. If he wants to indicate that what he has observed that is going on, that's one thing. But as soon as he starts getting into any kind of technical comments, then I'm going to have to say that he is not qualified to be commenting on that. I'm going to cut him off. I just want you to be aware of that.
Hold on. And Mr. Lee,
Yes,
you have an LSRP who's working at the property.
yes,
He is working with the Department of Environmental Protection,
yes,
and he is in compliance, and you are in compliance, Bethel, with the environmental,
Yes.
Department of Environmental Protection.
yes,
And there are monitoring wells on the property, correct?
yes,
And those monitoring wells are monitored both by your LSRP and the Department of Environmental Protection.
Mhm.
Okay. And what does your LSRP do with respect to the wells at the property?
yeah.
Well, I'm going to, when you say what does he do, what that becomes a question of sort of technicality. What is, if you want to ask him what he observes.
Yeah, what do you observe the LSRP doing when he's there?
So the previous LSRP had a vapor test 3 years ago for the public health. But
Okay, and I apologize. It's my fault, not yours. I didn't understand what you said. Could you repeat it, please?
yeah, vapor.
VAPOR, vapor?
Vapor,
Okay.
yeah, yeah. So everything was negative.
Okay, we're getting into the technical things, which I don't have a problem.
And also because of
That's why
Mr.
they-
Hold on, Mr.Lee. Hold on.
Mr. Stern.
I think he can testify as to what his understanding was as to what happened.
Well,
He's the owner. He
the
employs
mere
these
fact
guys.
that he's the owner doesn't make him qualified to be able to testify that everything was clear. I don't know what that means.
Okay, I don't know if he's testifying to that, but
He just did, and that's what concerns me.
Right. Does your LSRP generate and the reports that he gives to the DEP and gives to you?
Yes,
And do you have a copy there?
yes, this is the copy I got from my LSRP last year, and I gave it to the Chris about this, but he didn't mention about the the data of the water level.
So you gave this to Mr. Kasen.
That's as far as we're gonna go.
Because Mr. Stone likes to know what the status of the groundwater, but this is the data. So that's why I like to tell you.
Well,
in the
with all due
public-
respect, Mr. Lee, the report, if your counsel is going to submit that report, that's one thing. The data will then speak for itself. I'm concerned about you interpreting and reading that report.
I would submit this for, let it speak for itself.
I guess we'll call that 01.
Do we want to mark Mr. Steck's report too and give that a number?
We can, then we'll let Mr. Steck's report as 01 and this report. What's the date of that report?
Okay, the date of this report is October 31, 2024 at 3:22 p.m.
Chris, sorry to put you on the spot. I just want to confirm, you received this LSRP report, and you reviewed it in the preparation of your presentation for the board this evening and your investigation?
Let me just get a copy of that.
Yeah, look at it.
Yes, and I believe there's a follow-up email.
Okay.
I reviewed as well.
Because I know Mr. Tom said, Mr. Kasen's is not an expert either.
I understand.
This is something that they consider.
I wasn't saying that he was.
I
just
no, I
wanted to
understand it.
clarify it's the same report that your client said that our expert relied on.
Yep. Thank you. That is it.
That I need.
Oh, you need, well, that's the only copy.
Well, if you would like.
Yeah, if you like to, keep it.
Hold on.
If you would like, I don't want to steal this only copy, so why don't we end up having a situation where, I don't know that we can do it now,
Right.
but what I would like is that you will represent to us as an officer of the court
that you will take this in your custody and reproduce it and submit it to our board secretary.
Absolutely. I'm gonna make a copy and give it.
Oh, okay, but this number I have to carry. Okay.
No, they won't let you. It'll speak for itself. They can read it.
Oh, okay, they can, okay, okay.
Thank you.
Mr. Olson, do you have any further presentations
No,
or
but
testimony?
is that an LSRP report? Is that what that is?
Yes, I believe so.
Who's the LSRP? Does it make reference to this?
This is Ravi Kumar, Kumar.
Oh, no, no.
Who's the,
His name is Michael Dempsey.
Oh, okay, yeah, there's two Mike Dempsey. Okay.
Michael Dempsey.
Mike Dempsey.
But Ravi is an engineer.
all right, for what it's worth. So you'll photograph.
Yes, and I'll get it. Here.
All right, Mr. Olson, I thank you for your presentation.
Thank you.
And if you're finished, I'll ask that your client to step back.
Yep.
And I'm going to give the members of our board the opportunity to speak to our planner regarding the presentation.
Yes, that would be fine. I think that there are a number of people that I think should be up to public first. and then go back to
Before,
work.
we make a, can I make a request for a 2-minute?
Oh,
movement.
yes.
That's
Why
that's
don't we take
fundamentally
a
important.
5-minute break here to let everyone breathe, stretch your legs, and then we'll come back at 9:50. Thank you.
Yeah.
Be prepared.
No, I know.
That will do.
Don't worry about it.
I am loath
I know.
But I will definitely cut it off at 11. We're not going till midnight. We're not doing it. Hello?
I gotta get out of this thing.
Oh my gosh. Thank you. Call it a battery break. That's what we're on.
Oh, that's nice.
I can tell you one day, my office, we're doing a traffic signal study. We're gonna try to inventory in our region, all the traffic signals. Try to get their age. Some of the stuff. Yes, I know, that's come up. That's come up. That's a little harder. A little harder, but yeah. That's nutty. Municipal, they've heard that, they've heard that. Some of them are private, there's a couple in Jersey City that are privately owned. It's nice.
God bless you.
And so many of them are not MUTC compliant. Yeah, most are.
Hi, how are you doing?
I am just trying to get information on the table. I appreciate the compliment. You out of batteries? Is that what you're telling me?
Battery's gone, battery's gone. I was gonna say, we did the public comment section. You don't do Zoom.
We do now.
You do now, so no one ever told me that.
Oh.
Because it's like, who's the one?
We do Zoom now.
Yeah, no one said that.
Oh,
Like,
that's
who's the one, who's the one that tells the person? It would be me and no one told me. That's all right. It's just everything changes. No one says.
Yeah, we decided for the new year. I think we're gonna open up for Zoom, see how it goes with this hybrid situation.
I'm listening to everything that you're saying. Maybe you're saying too much.
Yeah, she can
I don't have any control. You have control.
Yeah. It's like, oh no, when you said it, I was thinking, well, you don't want to say that to me.
Okay, it's gonna be done.
No,
Yeah.
So that's why.
Yeah, no, when we go to the public to try to get through as much people as we can. I don't want to bring it up if we don't have to. So, here.
So, is one of the microphones gonna be with somebody here?
You can take the microphone now because he's, oh, no, we're gonna need it for members of the
That's what I'm saying. They go up there for a second. So you can show everything in the back. So you're gonna need somebody here.
Chris has his own microphone too, right?
Yeah, the show. That's what I'm saying. They can do it on like Zoom call.
Oh, well, when you do the Zoom call, we'll go with the public and we'll get a microphone. Cute, now I can wait for the next one to start writing.
I've seen a lot
By the way, I did test. I tested yesterday. I won't tell you how the test was out. But I did test.
You'll know tomorrow. Right. So, talk into the microphone here.
Everyone here needs to have a lesson in how to use a microphone. I have been sitting here since, 8 o'clock, no, 7:30.
Correct.
And I only catch half of what you are saying. And I think it is a really important thing to hear everything that is being said.
Well, that's the problem of this attorney.
All right. Hold on. I wanna get the meeting reopened. Hold on a moment.
We're starting up.
Fair enough. I appreciate the feedback. Thank you very much. All right, it is 9:51. We're gonna call the meeting back in session. I think everybody's present and in their seats. Thank you very much. At the advice of our board attorney and Phaedra, we will definitely still let you have time to talk to Chris and everyone else afterwards. Because it's getting late, we're gonna open up the meeting to members of the public wishing to be heard on this application. We're gonna start with members of the public who are present. And everyone's gonna have an opportunity to speak. We're gonna ask that you keep any comments directly to this application and please keep comments to 3 minutes. When you come up, you'll be sworn in, you'll state your name and your address for the record. Please spell your last name and speak into the microphone. Sir, I saw your hand up. Why don't you come up? There's a microphone right here on the table.
I have a bad ankle.
Oh, then someone can, thank you so much.
I sprained it in the snow, so.
Sir, do you swear or affirm the testimony that you're about to give will be the truth? So help you God.
As a Quaker, I affirm, yes, sir.
Would you be kind enough to state your name, spell your last name, and give us your address?
Robert Pritchett, Pritchett. I live in Somerset, New Jersey.
Thank you, sir. Go ahead.
First of all, it's been a very eye-opening experience for the last 2 hours and a half. I'm a customer of at least 25 years of Mr. Lee. He's not just the only dry cleaner in town, at least, but he's the best dry cleaner in town. I started going there because he put up a sign that said organic cleaning. And I went in, he gave me a tour of his facilities, he showed me his machines and everything else. I've never had a problem with the parking lot. I understand, well, I know that he repaid it at his own expense. I've had more problems with people and kids on skateboards and bicycles riding on the sidewalk than I have with cars. I come in to get my dry cleaning and I often stop at Raceway to get gas. I stop at Baskin Robbins or Dunkin' Donuts to get something to eat. And I often go to the usually the Stop and Shop. So if you take this over and this place no longer exists, I'm not gonna come in and patronize businesses.
And that's pretty much it. And by the way, they just don't do dry cleaning, they do it the same day if you need it, and they're the best in town. And one other thing, I'll be real quick, is that this is a private business which has people on payroll who get paid, they pay taxes. And one other question is, all along Raritan Avenue, there's all these places that you've taken over, they're abandoned. I remember some years back, there was one of the mechanics put up a sign, don't take my business. That seems to be what's going on here. And what's gonna happen to this land? Are they gonna build senior citizens housing here? It's gonna be low income housing? Or you just don't know and you wanna take over this land and this private business?
Thank you, Mr. Pritchard. Anybody else?
Thank you.
Yes, sir. If you don't mind coming up. And we now have our MC take care of the microphone.
Thank you, Ms. Wilson, we do appreciate it.
Sir, do you swear or affirm the testimony that you're about to give will be the truth, so help you God?
I affirm.
Your name, address, spell your last name, I'm sorry, your name and spell your last name and your address.
Stephen White, like the color. That good enough?
That's good.
I live on North Sixth Avenue in Highland Park.
Thank you.
It's about the parking, isn't it? Really, Mr. Cosenza's discussion of the parking lot was a very, very nice academic planner's view of the parking lot. And that view has nothing whatsoever to do with how the parking lot is actually used. At least 7 or 8 of the spaces are viable. I'm a 25-year customer too. I use it all the time. Do you? I've never had a problem. There's no problem with egress, ingress, any of the above. People use it to come in, drop their clothes, and leave. And it functions extremely effectively for that. I won't say further about the tent space, but you don't back into the parking. You don't back into the sidewalk. You just don't. But really, ultimately, it's about the parking, because as much as Highland Park is a walking town, this isn't a walking business, because people bring their stuff, and they bring their stuff in their cars and they leave, and some like this gentleman come from out of town because so many people have closed up. What you're planning to do is take away a 75-year-long viable business that works well, that some business like it is going to be necessary in town after a redevelopment anyway, but this is already viable. Why disrupt it? And if you really feel that this property is the one that's necessary for your redevelopment, then give Mr. Lee a way to have an equally viable business at the other end of things, which means including parking, and it means including what he needs to run a viable business. And so far, if he is held out from selling, it's because nobody's offered him that. Thank you.
Thank you, Mr. White. Sir, do you swear or affirm the testimony that you're about to give will be the truth, so help you God?
I do, yes. Lois Loving,
Spell your last name for the record.
Lebbing, but she knows how to spell
Well, for the record doesn't know how to spell that.
Okay, and North Second Avenue, and I'm right behind the cleaners. I'm their neighbor, he's my neighbor. I'm behind the gun shop. I'm on the corner of Denison where the nice blue house used to stand until it got eaten by human termites, but that's another story. Or redevelopment. Okay, I can't imagine, when I read the criteria for redevelopment back in whatever, 20 years ago, vacant is a vacant place. There's a factory falling down, an undeveloped lot, a natural tree, shrub, weed, critters, deer, fox is not vacant, it's undeveloped, and that's what we need. I have a photo from 2008 maybe, although the borough has repaired some of the drains. Dennison Street was flooding so rapidly, right there behind the now borough ugly gun shop, that a young man moving had his boogie board out in August, and he floated down Dennison to the garages. And I got a photo. So don't tell us we don't need trees and grass and a green area, which is behind Ubreeze, pronounced Ubreeze, it was instead. We appreciate that area. It's a pit stop for little critters. It's got trees to clean the air. We don't have to pay every inch in Highland Park. But okay, so the borough owned gun shop had to buy it. It still has graffiti. I asked Mayor Dale, please, can you paint the graffiti off the back? And that expert or another expert said, oh, it's got broken trees, tree branches, and it's not cleaned up. So don't think on a business, a friendly, helpful business, that if we can go to the moon and sometimes come back, why can't Deborah, a Raritan developer for Tract A, why can't she build around the building? It's not attached to the gun shop. They do it all the time in New York, maybe Atlantic City. Take down the surrounding buildings, leave a nice brick building. Why can't it just be there? Her development, Deborah's development is the Grove. We looked it up on Easton Avenue, right opposite Rutgers Prep. It's an enormous, gorgeous development, 4 or 5 stores. I'll bet it doesn't have cleaners. Why not have a cleaners on site? Who else has that? Kaplan have it? No. Why wouldn't this be unique? Why not help? Why do we have to send McKinney away, 80 years here, McKinney Oil? We just moved to Ubreeze, which I can't understand why Ubreeze can get a location and the borough cannot find a place to put Mr. and Mrs. Lee. The family is next door to each other. You didn't move them. And so now he's suffering. Build around them. Thanks.
Thank you, sir.
Anybody else?
Yeah.
Yes, we need to have you, there's a mic right here on the table. Yes, right there.
I mean, you can go to the corner if you want.
Whichever.
I just.
Do you swear or affirm the testimony that you're about to give will be the truth?
I do.
So help you God.
I do.
Your name, spell your last name and your address.
Carl Montana, Montana like the state, Montana. I live on North 10th Avenue. I've lived there since 1968. I didn't come here for this. I have another question later. But I've shopped at since 68, so I've been going to that cleaners many years when LaCash owned. And I've never had a problem going in and that parking lot. And neither has my wife, who was there today. And I have to say, he's probably the best cleaner around. Our priest in New Brunswick asked us to bring, our priest asked us to bring the linens from the altar to him. Nobody else. And even his person, that's how much he's respected. So I don't think we want to drive him out of this town. This town needs him. So that's what I have to say for this. I would like to come up again later, ask you a question.
We'll do that a little bit later. Thank you. Anyone else?
All right, any last call for members of the public who
Right over
are
there.
present? Oh, I'm sorry, please.
Do you swear or affirm the testimony that you're about to give will be the truth, so help you God? Okay, you gotta get by the mic, please. Thank you very much. Would you tell us your name, spell your last name and your address?
My name is.
Right by the mic.
My name is Angela White,
Spell your last name, please.
WHITE. And I apologize, I don't have a lot of voice tonight.
Oh, it's well, I'm sorry, I didn't hear, I apologize.
WHITE. And I apologize that I don't have a lot of voice tonight. I do my best. And I live at North 6th Avenue. And I've been in town a little more than 40 years. I'm a walker. I walk around town a lot. I've been involved in a variety of organizations in town. I've worked in town and I've commuted in town. So I'd like to open by saying thank you, Bob Lee and your family, for providing a service to this community. When I moved to town, I used other dry cleaners. I used a variety of them, and I helped out friends, dropping off and picking up laundry. I've gone to his business and stayed with his business because it's been more reliable, because it's an organic dry cleaning business for a whole variety of reasons, and being familiar with other dry cleaners, most of whom no longer exist. I would like to say two things, and I'll be as brief as I can. If condemnation is based on parking, which is where a lot of the conversation has been tonight, I can think of a lot of other businesses that would be very quickly chased out of town. I've personally been on Route 27 waiting to turn left into Route 27 and watched cars back out. I've watched cars not find parking spaces by Dunkin' Donuts at the end of town near New Brunswick, and watch them circle and park in the fire lanes and block ambulances. There are a lot of problems with parking in this town. It's a familiar topic, and it's not a good enough reason for condemnation, in my opinion. And so a lot of this felt like trying to find reasons to get somebody out for the benefit of putting in a development. And I understand the need for development, I understand the need for tax spaces, I understand the need for more housing. I've watched a lot of the discussions for many years and come to various meetings or watched online from home, things like that. But I think there's a letter of the law and an intent of the law, and Highland Park is a town of love, and it's a town of respect, and I would hope that when we look to do things like economic development, we also do it with a sense of ethics. And when we have a business that's been in town this long and this respected, and I know that there are people from as far away as Pennsylvania, there are people from other communities like Edison that use this dry cleaner specifically also because they can clean religious articles, Thomas's and other things, because they're a quality service, and as was stated, they pay taxes, they go out of their way for members of the community. I think that's the kind of business you want to work really hard and bend over backwards to keep in town. Even if it requires a lot of effort on the part of the planning board and other parts of what makes our town work. It's business we really like to keep in town from my perspective. And I will tell you, I'm frequently in that, as much as I walk, I'm not taking my clean, dry clean and stuffing in a bag on my shoulder to walk back home again. I'm going there with the car to bring my dry clean home. And I've never had or witnessed a problem with that parking lot. I've used it really well. So I'd like to speak in defense of Mr. Lee and in support of general concepts of this town moving forward. But it seems to me there ought to be a way that we could work that out, and I haven't heard it over the various discussions that I've tried to follow over time. I'm not on the planning board, I find other ways to be actively involved in the community, to volunteer, and to do service to the community. But I do try to follow some of these discussions, and I think we could do better. Thank you. Thank you for your time, thank you board members for your service.
Thank you.
Thank you.
Are there any other members of the public present tonight who wish to be heard? On this application, we'll reopen for public comment afterwards. Are there any members of the public at home that wish to be heard?
There are no attendees.
No attendees? We're not that interesting? Okay.
There were.
Fair enough.
Darn.
All right, then with that, we can close the public
Yes, we
portion.
can.
We can close the public portion of comments for this application. Again, we'll come back to general comments later. And I will ask Chris to be available to answer any final questions or comments or discussions from board members. Please, you're waiting very patiently. Please go ahead.
Christie,
Thank
have a
you.
mic?
Am I speaking loud enough? Can everybody hear me? Okay. I have a couple of questions and then I had a comment about all of the testimony that I've heard here tonight from Chris, from Mr. Lee and his legal and planning team, and from the members of our community. So my first question for Chris is, I know we heard a lot tonight about the contamination that was found on the subject property. And the borough has acquired the adjacent properties, lots 48, the Ubris, and lot 47, the gun shop, And in the report, there was PCE that was found, TCE that was found. I will not try to pronounce the actual names of those chemicals because I cannot. And vinyl chloride. Is it possible, and I just, briefly looked up what these chemicals actually are, PCE being a chemical that is specific to dry cleaners, but TCE and vinyl chloride could also be byproducts from the auto body shop that was on lot 46 or 47 for a number of years. Is that possible?
Since I'm not an LSRP or environmental scientist, I don't have the answer to that.
Were there any other chemicals that were reported in the report when they did a sampling of the soil, or they were testing the groundwater around that area besides these three that are noted in this?
There may be, but I think I'm focused on this three. So I can't really answer that question.
So with the borough now having possession of those other two lots, are they making any efforts to work with Mr. Lee to remediate the area, or is this only falling on him?
It's my understanding that Mr. Lee is a responsible party. If the borough were to purchase the property, they would assume all responsibilities.
Okay, but does the borough assume any responsibility for cleanup on an area where there was an auto body shop for decades?
I don't know the answer to that. I'm not sure if Mr. Councilman Hale has the information.
If we own it, so we have responsibility. So the properties that we own, we take responsibility for. The properties that we don't own, we have responsibility for the current owners.
Okay, understood. So is the borough actively remediating the properties?
So none of the properties that the borough owned have the same sort of designation that this property has had from the Department of Environmental Protection, is my understanding. Again, I'm not an LSRP either.
Right.
But what I'm saying is that none of the other properties that are there have ever had a judgment saying that there is contamination on their site and they're the responsible party. So Woodbury's never had the Department of Environmental Protection saying that he was the responsible party. The other ones down the side, or the gun and boat, or all of the ones that required, they've never had those determinations made by the state.
Well, did they not have those determinations made because they were not investigated?
I can't speak to that.
Okay, so I'm not sure if investigation is the right word, but for whatever reason that lots 43 and 46 and 49 were investigated, but the other two lots that had auto body shops on them were not. That doesn't make sense to me. Like, why this lot and not the adjacent lots?
I don't know that Councilman Hill was saying that they weren't. I think he was saying that he doesn't know if they were or not.
Okay.
Here. Oh, I don't think Councilman Hill said that the other lots owned by the borough weren't investigated. I think he was saying he doesn't know, but
Yeah, right. As far as I know, I don't know the answer.
Okay. Okay. So based on the testimony that I'm hearing tonight, you have a business that has existed in our community for 75 years and in my opinion has served this community well and is a stand-up business that I think as a borough should be applauded and not kind of nitpicked. I think that, what we're seeing here is an opportunity for the borough to develop Track A, and the borough has done a really great job of making very strategic acquisitions to achieve the goal of enhancing our downtown and bringing more economic growth and development into the town. The Classic Cleaners is, in my opinion, an exemplary example of a small business in the community that has served the community, that has the respect of the community. And I would hope that we could find a solution that does not only displace a business that appears to be, and is apparently an institution in the community, but would also displace the tenants that live above it. I hope that we can find a solution that does not displace this business and that allows this business to continue to serve the community and serve as an example of entrepreneurship and community service. So, you know, I hope we can find a solution to this that just does not, that doesn't erode that doesn't rid us of that as we want to continue growing this downtown and showing new business owners, you know, what serving your community for a long time, what it looks like. And you're not just a shop, you're a part of people's lives, you're a part of people's everyday routine. And I'd like to continue seeing that. I'd like to see more of that, and I'd like for us to find creative solutions to that.
Chris, yes.
I just want to offer some feedback on comment made as well. I met Mr. Lee at the shop, and he assisted me during the investigation and showed me.
Chris, you need to bring it back closer to you.
He gave me access to the building, respectively, to go to the second floor. We had tenants or family members up there, gave me access to basement and property, and we had productive conversations, which included the possibility of relocating. It's my understanding since 2019, so we're going at least 6 years, that the borough has tried hard to accommodate the possibility of relocating business, because I think everyone, at least my observation is that everyone recognizes it is a stand-up business. They stopped using the chemicals 20 years ago. So this study is really an analysis of the land in question, not the business. So I just want to make sure that that's clear. I enjoyed my time with Mr. Lee, and I hope there is a productive solution. And my understanding, it is happening behind the scenes, but out of fairness to Mr. Lee and the borough officials for that matter, I can't comment on what those things are. So in sum, the borough is actively, it has been for years, trying to find a way to relocate the business, as it has done for Newbury's.
Does any other members of the board want to make any general comments or questions for Chris?
I just want to go over, which I feel is the crux of the issue. Could you review the, I forget what the nomenclature was, but the hole in the donut, and whether that by itself, if it meets that criteria, that's enough to show this property in as need of redevelopment, which includes condemnation. Could you go just review that in
okay, I'll try to keep
basic
it
terms.
a high level in basic terms. I try to structure my report so it's easy to understand this, and that's why I separate the condition and the analysis on a per lot basis. In this case, it fit neatly because there is a building on one lot, there's just a parking lot on the other, and vacant land on the other. If you review the statute, it states vacant land doesn't really indicate, in my opinion, the entire property. So whether it's one property or 3 separate lots, it's irrelevant. There's vacant land of which occupies more than 57% of the whole lot. In my opinion, this is criteria C. And then I went through the various things, and I didn't pick one thing of one aspect of the property that meets the criteria D. I reviewed many conditions. So in sum, all those conditions show that there's a faulty arrangement design and or other factors that make it detrimental, which includes contamination. If the statute doesn't accommodate or anticipate that contamination is somehow not detrimental, I don't understand what the purpose of the redevelopment is. And in addition to that, if the board were to take the position that it does not meet the criteria C or D, I have the just in case statute that if the board were not to make that finding, you could rely on criteria C because it is proverbial hole in the donut, because there is a redevelopment plan that anticipates its collective and consolidated redevelopment by assembling all the properties. The plan anticipates that whole development. In fact, in 2001, the plan, which has to provide zoning to allow for construction, has it contemplated it would be built in 2 phases.
when we went through the RFP process, we got a response that said, I want to develop it all at once. And we're going through that process, potentially amending the plan to amend regulations, but there may not be a need to do so. Depends on what the concept plan is, what we can move forward. So there is a plan in place by virtue of the redevelopment plans to have all development as a contiguous development. I think it would be inappropriate to have a site plan filed, pause it, and then have a redevelopment study.
No, I don't have any problem with it. My main question was whether let's say that the inability of the borough to come to terms with the property owner constitutes, and the fact that it remains, the hole in the donut, does that by statute constitute a reason that we can pass this, whatever the act, that says it can be condemned? In and of, just on its own,
I want to separate condemnation or proceedings from area need study. Because if the borough
area need studies that includes condemnation. Condemnation would be essentially it's a bargaining tool. That's what, like, again, it's about what will be acceptable. And just to make a comment, coming from a background of being a builder, if I was to look at this and say, oh, but you have to leave this section and work around it, I'd walk away. I mean, people have this inflated idea that people want to build in Highland Park, and yet we've had an empty gas station on the corner of South Second for what, 25 years? If everybody wanted to come and, that's why I think we owe it to ourselves to really do due diligence to try to maximize our ability at redeveloping our communities. That's what I have to say.
Go ahead.
I agree with you, Kendrick, about the maximizing all the tools available for redevelopment. And since you bring up the gas station that's empty on the corner of South Second, opposite Fish Dry Cleaners, I would love to see that being brought before us for redevelopment and condemnation, because that's actually something that is blighted and looks awful. And
I'm sorry, they got multiple people. Who I
I'm
think are about
sorry,
to tell you.
but there's, okay, but it isn't, it's coming, it's not here yet. I mean, this is not a blighted building. This is a functioning building with a functioning, thriving business with a tax-paying business owner, building owner, tenants that pay their rent. There are no violations. I mean, this building is in much better shape than a lot of other buildings that we see in this town. And I know that everything's not before us this evening. And I totally understand the hole in the donut where, if you see, you have this whole big lot that the borough's worked really hard to acquire. And there is this one spot that, just doesn't fit quite in the puzzle and makes the puzzle incomplete. For me, I don't know that that is enough to condemn this property. I don't think that it fits the criteria.
No, I respect your opinion. I'm just trying to, because it all comes down to the law. And we have to follow, the rule of law. And I'm just wondering, is the law there? And what the, things are. So that's in my head what I'm going through. It's not, I have no problem with the business in and of itself. Like many of the others in Highland Park, it's a bit of a hodgepodge, and that's, in a sense, part of our charm. But we do have an overwhelming need to bring in development to at least stabilize our tax base. And if you look at lot 43 and compare to everything around it, it is a small little piece that is holding up a huge potential bonus to the entire community. And, like I said, it's all about the law and whether, we meet or whether the proposal meets the law. But I'm just saying that there's a lot of, there's two sides to the story.
To that point, I just want to rely on really the definition of the Section 3 criteria, which, again, if the board were to say, I don't agree with the report that it meets criteria C or D, you can use Section 3 criteria because it's land in and of itself does not meet the criteria, but may be useful for the effective redevelopment of the area. Sounds like I heard you say already it's a small piece of a large development. That would effectuate a productive redevelopment plan. was already in place.
I understand.
Thank you, everyone, for everyone's comments. I'm gonna make one final comment here on this.
Wait.
Oh, I'm sorry. Did I miss?
Sorry, I didn't mean to
Go ahead.
interrupt you, but
That's all right. Go
I didn't want to not have a chance to ask a question for our planner. Can you tell me if there are laws or policies for ethical relocation of tenants when redevelopment like such as this one is done? Can you give more detail?
Yes, it's my understanding that if the borough were to pursue, if they were to pursue condemnation, it would be required to prepare what's called a WRAP, WRAP, Workable Relocation Assistance. And it's my understanding that if we need to do so, we will do so.
Okay, and who in that building would be covered by would the WRAP apply to?
It would apply to both residences and businesses.
Okay, so if there were condemnation, the business would have to be relocated at the borough's expense? Is that what I'm understanding?
I'm not sure about the expense, as I have not done a WRAP myself. It's my understanding that the redevelopment attorney would be able to draft one on behalf of the borough and redevelopment.
I maybe would offer just a small bit. Again, I haven't done a WRAP either, but I am familiar with a redevelopment attorney's discussion of the WRAP. There is relocation assistance, and there's also relocation assistance as part of a consensual agreement if that were to come. So you can have if it's condemned, there's definitely has to be relocation assistance. If it is part of an agreement, you can have relocation assistance along with purchasing the property or something like that. So there's a number of different mechanisms that would help the tenants and the business move, even if there was a possibility that there was a negotiated settlement towards a purchase. So that's part of the WRAP agreement is baked into to this part of the statute, is my understanding.
So it sounds like there would be a provision for relocation of commercial and residential tenants in either case?
That's my understanding, yes.
I feel better the borough's not kicking people to the curb and walking away.
So I'm sorry, just to follow up on that. So would that also involve compensation to Mr. Lee for the cost of his building?
It's my understanding through the eminent domain, has to offer a fair market value for the property.
That is absolutely correct. There has to be a determination of what fair market value would be. And that's a process separate from this board.
Okay.
All right, last calls. And I'll say this is a preliminary investigation of a condemnation in area in need of redevelopment. We're being asked to decide if this area is in need of redevelopment to such an extent that we would authorize the borough to use condemnation powers if that's what the borough decides to do in the future. It's a very serious step to take. I think no one on this board takes it lightly. We've heard a tremendous amount of testimony tonight about it and how great Casa Cleaners has been as a business and continues to be as a business for this community and how valued it is. All members of this board live here. I think we're all very familiar with the site, the location, and the history of the site and what's been happening or not happening in the surrounding properties, along with all the history of the redevelopment discussions that we've had up till now. So with all of that vast weight of history and knowledge and experience, we're going to take a vote on whether this should be considered an area, a condemnation area in need of redevelopment. So I think the board is ready to vote. And with that, I'll solicit a motion on that. Oh,
If
no?
I can, well,
Go
no,
ahead.
you're very close. What I would suggest is that the board's responsibility is that you will be submitting by way of a resolution, a recommendation to the governing body that the area or part thereof should or should not be determined to be a redevelopment area. And that recommendation is made to the governing body. So that's what you're doing. You're doing a recommendation predicated upon the report that you've heard together with the testimony that you've heard as well. So it's a recommendation. You've heard, I don't need to go through all the testimony, you've heard it all. There's the possibility that be under the criteria either, as Chris has made reference to, either C or D. The issue that has been raised by Mr. Steck is whether or not the contamination is something that should be part of it. He's saying, well, it shouldn't because of the fact that it's being remediated. Respectfully, I disagree with that position. I think that it is a situation where there has been at least reference to the fact that this has been going on since 2000, for 12 years, whatever it's been, and it's an ongoing process. And that process, if it is ultimately, the property is ultimately acquired by the municipality, that process will continue to then be the responsibility of the municipality. There's also the fact that under section 3, and as you've already heard, that section makes it clear that, excuse me, that if the property is necessary to effectuate the public purposes of the act, and it goes on to indicate that the redevelopment area, which includes lands, buildings, or improvements, which of themselves are not detrimental to the public health, safety, and welfare, but whose inclusions is found necessary, excuse me, with or without a change in their condition for the effective redevelopment of an area for which they are a part. That in and of itself is a basis for the determination of it being a positive recommendation. So what you're looking for, Madam Chair, is a motion to make a recommendation to determine whether or not you are recommending this, as has been indicated by Chris, that it would be, it would give the borough an opportunity to determine that this is an area in need of redevelopment, either with or without condemnation.
Does the council have to?
Can't hear you.
Sorry.
By the mic, by the mic.
Does the borough council have to follow, can they disagree and say it is condemned? Or
If the resolution would be that the board would recommend that this isn't condemnation area in need of redevelopment, it would be up to the council's discretion whether or not to exercise the powers of condemnation in that regard.
Thank you.
So are we gonna be given the recommendation with condemnation and without condemnation?
That's my understanding. That's my
Separate things, or-
understanding. Correct, Chris? It is with the possibility of with condemnation and without condemnation. It's at the discretion of the governing body.
This ordinance will empower, if they passed an ordinance, it would empower them to use condemnation.
Correct.
Whether they choose to or not is.
So the answer is it's with or without, but it empowers them to be able to do that.
Okay.
To be clear, the alternative would be, if this was a non-condemnation area need redevelopment study, the recommendation would be to council to declare as an area need redevelopment, but there'd be no possibility.
Understood.
Of eminent domain.
This just includes the possibility that would occur. And I don't disagree with Mr. Olson. I don't disagree with Mr. Steck, or for that matter, any members of the public. This is a significant step. I agree with you. So you need to think about it. But that is the situation. They have the opportunity. They are not required to exercise it.
If we were to declare this a non-condemnation redevelopment area, would that not be redundant to already existing declarations of redevelopment for this area?
I don't know that you have that option. In other words, the option here is that it's a request for determination, including the option for condemnation. So that's what you're being asked. It's there. It's part of this presentation to you. So it's not like you can say, well, we're going to declare it, but we're not going to include condemnation. That's not your option.
That's not, okay.
Thank you.
That was my, thank you for
Clarification, yes.
We cannot convict on a lesser included charge.
Correct, not this evening.
Well, I don't know that I would keep using the criminal reference, but essentially, yes.
So would anyone like to make a motion on whether we should make a recommendation to council on whether this is a condemnation area in need of redevelopment?
I'll make that motion.
I'll second.
So the motion would be to declare that this is a condemnation area in need of redevelopment, correct?
Yes, and all three lots.
All three lots.
Yes. And just so it's clear, because I know that
you folks know it, but I've had a situation many, many years ago. If you vote in favor of this, you are voting in favor of the recommendation. If you vote no, you're voting against it. Just so it's clear. I know it's fairly simple, but I had a situation many years ago where it didn't seem clear to some board members. So I'd like to explain it, and I also always ask for the board to, the chair to solicit a motion in the positive so that there's no misunderstanding.
Very good. All right, we have a motion and a second. So we will take a roll call vote, please.
Mr. Brusher,
Yes.
Mr. Chin,
Yes.
Ms. Hazy,
No.
Mr. Hale,
Yes.
Mr. Malay,
Yes.
Mr. Perlman,
Yes.
Mr. Stern Cardinal,
Yes.
Mr. Williams,
Yes.
and Ms. Hill.
It is with a lot of forethought and gravitas associated with this decision. I too say yes.
The motion passes.
Okay, thank you very much. With that, I will open up the meeting to members of the public on any non-agenda items who may wish to be heard. Come on up, sir.
And again, I don't know what happened to the mic, but, oh,
We're traveling.
again, sir, if you just be kind enough to just restate your name. You don't have to spell it, we already know that.
Right. Carl Montana.
Thank you.
I live at North 10th Avenue. I've lived here since 1968. Almost 2 years ago, two friends of mine got killed at the corner of North 10th and Raritan. There was a large outcry. I'm surprised some of your members don't even know about that accident that I was talking to. Yeah, I don't know. Are you all aware of that accident? Anybody not?
I'm sorry, can you please repeat the accident?
It was on the corner of North 10th and Raritan. The driver later was determined to be doing over 90 miles an hour.
I am aware of that.
All right. People that were killed were friends of mine. Their children, their son and their grandchildren live on my street. At the time, we were told that the mayor was talking to the governor. It was a big deal. I was on TV because I was very upset because I had been talking to your police in person for over a year and a half before that about that corner. And I was told, I'm not going to mention names, he's still on the force, and he's a very good guy. Nothing he could do. I was saying, you should do something. How about putting a flashing sign? How about putting those signs up that say your speed and blink? Everybody has them except us. It's a state road. Well, the state can work with us. I want to know what's happened since then, because I understand that there was a study that was supposed to be done by the, yes, you see, that's why I'm wondering what's happening. There was supposed to be a study by DOT talking about bike lanes and all kinds of stuff. Nothing has been told. We don't know what's going on. The couple whose parents were killed there don't. I asked them today. They don't know any more than I know. Can you tell me what's going on?
We can't. And the reason why we can't is that unfortunately is not within the jurisdiction of this board. If you want to know information,
the mayor's yours.
No, I'm not the mayor.
Oh, you're not
the chair of the planning board.
This is-
However.
This is only the planning board. This is not the government.
Oh.
Say, sir, we do have.
So thanks for coming.
Thank you very much.
But it's the wrong board. You need-
I'm a member of the Borough Council and I'd be happy to discuss this with you after.
After the meeting, I really just,
Yeah, absolutely. But as our attorney said, this board.
this is not the
one-
right place. I thought this was a board.
We're the
Well, I'm
planning.
glad I came because I had something else to say.
We
Yeah,
charge.
so
you
I'm
the
happy
next-
to talk to you afterwards and talk to you about the progress on that.
I would really appreciate that, even though it's almost. Thank you.
I'm sorry for your loss.
Well, yes, and the grandchildren and the parents that, okay, thank you very much.
Thank you very
Who wants
much.
the mic?
sir.
I mean, just
You give it to,
just so you know, that we have a bike and ped plan that we adopted as part of our master plan, the end of 2019, and we are implementing it. So that is specific crash.
That was-
fatalities you're talking about,
That's a
that's
huge,
not-
that was an exception. I understand the guy was doing over 90 some miles an hour. They triangulated it, they figured out his speed. And I understand that, but there were other accidents on that corner frequently. And I've been there since 68, and it's a dangerous corner. And people do not slow down. Do not slow down as they should be according to the speed. And I know the police have been there. I'm telling you guys that, but I know the police have been, I don't know how many tickets have actually been given.
Sir, if you don't mind, just put the mic on the table. Thank you very much.
Yes, I am. Hi again, North Second Avenue. Since this came up, well, excuse me, I'll start with, I have a 3-month-old New Jersey Department of Environmental Protection remediation plan, a site plan program pending sites confirmed contamination. Anyhow, under active, we find Bethel. Under active, we find Newbury's. Under active, we find JSM and Highland Park South 6. So my question is, what is the status of Gabriel Estates? Has that come before this board, and been passed at all? And what is the status of the cleanup? And lo and behold, under active, I can show Councilman Hale, 133 Raritan Avenue is the gun and boat vacant space from what I can figure, because 13739, I believe, is the restaurant, the busy restaurant. So it is it's a 3-month-old list. You can pull up your own. I didn't do this, my sister did. And it's active and it's not been cleaned, and the borough has owned it for I don't know how many years and was after it before then. So it's on the lease, and you know, it's not fair. But what is the status of Gabriel Estates, and when are they gonna clean up? And I know that was litigation, and so was South Second. That developer is playing games. It has nothing to do with making it pretty. It's payback for Highland Park's Buck Woods. Yes. Status of Gabriel Estates, anybody know?
Again, the planning board, you're absolutely right. The planning board did get involved in that application and did review it extensively and then approved it. At that point, unfortunately, at that point, it is no longer within the jurisdiction of this board to monitor things such as what's going on thereafter, building permits, things of that nature, and in particular, what you're asking for, which is the status of a cleanup. That is the subject of the developer and the DEP. I don't know. I'm not going to speak for Mr. Hale, but I would assume that there would be some information at the township. I'm sorry, at the borough level that might be able to be available to you, but it wouldn't be at this level.
Wait, let me rephrase it. I think that was made almost 2 years ago, 2023. Has Gabriel Estates come before you within the last 2 months?
No.
Yeah, thank you.
Any other members of the public wishing to be heard on non-agenda items? Okay, seeing none, I'm going to close the public portion of tonight's meeting. Normally we go into reports, but frankly, unless Scott, you're dying to tell us something. At this point, I'll solicit a motion to adjourn.
So moved.
Seconded.
All in favor?
Aye.
Thank you very much, everybody.